Well, the next item of business is under K, statements on a matter of public official responsibility. The statements being made by the Assistant Chief Minister regarding the States of Jersey Complaints Board findings of Mr. R. Ahmad's complaint. Assistant Chief Minister.
Thank you, sir. Good afternoon. Members may be aware of a complaint made earlier this year by Mr. Rizwan Ahmed following a decision not to grant him entitlement for work status. Together with my political colleagues on the Housing and Work Advisory Group, we have considered the findings of the States of Jersey Complaints Board, published under R137 of 2021, and have reviewed the decision not to grant Mr. Ahmed entitled for work status. As chair of the Housing and Work Advisory Group, I have discretion in terms of determining whether there has been a continuous period of ordinary residence in any particular case. In the case of Mr. Ahmed, this discretion extended to his treatment as a person with licence status under paragraph 65, sir, of the policy guidance, and secondly, in deciding whether he had maintained Jersey as his home during the period of his extended absence to care for his ill mother. Mr. Ahmed's case highlighted an inconsistency in our policy, which we have since addressed. The need for a person to be absent from the island to care for a family member should be the same, whatever the residential and employment status of the person. And it is that need which should form the basis of assessment as to whether ordinary residency has been maintained. Paragraph 65 of the policy guidance has therefore been amended in order that the policy will now be applicable across all categories of residential and employment status. And I'd like to confirm to members that this does not mean treatment of entitled for work only and entitled status individuals should be the same as licensed and registered individuals in every circumstance under the guidance. However, in the case of caring for a family member, it is appropriate to treat people equitably and to apply the same treatment across all categories of residential status. In their report, the States of Jersey Complaints Board raised concern that the policy guidelines are unreasonably restrictive in that they refer only to caring for a parent or child. I would like to confirm that paragraph 65 of the policy guidance does already state that absences whilst caring for a person other than a parent or child may be considered on a discretionary basis, subject to the provision of sufficient information regarding the relationship between the person and the other person for whom they intend to care. We feel, sir, that is sufficient to cover the breadth of relationship that may exist between an individual and a person, sir, that needs essential care. Following a meeting between the Housing and Work Advisory Group, Mr. Ahmed and Mr. Ahmed, sir, his case was reviewed, and it is accepted that he falls within the criteria set out in the revised paragraph 65 of the policy guidance. He is therefore deemed to have remained continuously resident in Jersey from October 2015 to date. Officers have communicated this decision to Mr. Ahmed, and he has been informed of his eligibility now, sir, for entitled to work only status. The government wishes to ensure that all individuals have a right to care for a spouse, partner, family member, or dependent who may be in need of essential care. And if that requires an individual, sir, to leave the island for extended periods of time, we feel they should not be penalised in terms of their residential and employment status. Thank you, sir.
Thank you very much, Assistant Chief Minister. There's now a period of 15 minutes of questions. Does anyone have any questions for the Assistant Chief Minister? Well, if no one has any questions, then that matter is ended and we move on to public business. Before we start public business, a decision needs to be made about whether to reduce the minimum lodging period in respect of the proposition of the Council of Ministers entitled Assisted Dying, P95. Chief Minister, do you wish to make the proposition under Standing Order 26.7, the lodging period be reduced to allow this matter to be debated at this sitting? Chief Minister?
I believe the Chief Minister may have delegated this this proposition to the Home Affairs Minister.
Very well. If that's so, Home Affairs Minister, then would you like to make that proposition?
I wish to propose that the lodging period be shortened for this proposition, sir.
Very well. Is that proposition seconded?
Yes, sir.
Does any member wish to speak on the proposition? If no member wishes to speak on this proposition, then I'm prepared to take it on a standing vote unless someone indicates in the chat they would like a formal vote to be taken. Deputy IA, you wish a formal vote to be taken. Very well. The proposition is whether or not the lodging period is shortened to enable assisted dying P95 to be debated at this session. A vote pour will shorten the lodging period to enable that to happen. A vote contre will be against. I ask the greffier to put a voting link into the chat. They open the voting and ask members to vote. I'm sorry, Deputy Sutherland, I have completely overlooked you, and I apologise.
No, I apologise. I've got the computer here, Phil. Could I register a vote for?
I'd like to register a vote pour. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The proposition has been adopted, 33 votes pour, 2 votes contre, no abstentions in the link, and a further 6 votes pour noted in the chat.
May we have the 2, please, sir?
Two votes contra were Deputy Lahegre and the Tab of Greville.
Very well. The first item then of public business is the Social Security Amendment of Law Minimum Earnings Threshold Jersey Regulations P79, lodged by the Minister for Social Security. The purpose of this debate, the main respondent is the chair of the Health and Social Security Scrutiny Panel. This debate resumes following the adoption of the principles on the 15th of September this year and the referral to the Scrutiny Panel. So, Minister, how do you wish to propose the regulations? There are 2 of them.
Yes, sir. Can I take the regulations on block, please?
Well, are the regulations seconded on block?
Yes, sir.
Does any member wish to speak on the regulations or any of them in second reading? Just reminding members we are in second reading, the principles have already been adopted.
So don't you want me to speak?
Well, no, I mean, your time to speak,
okay.
Minister, was when you proposed, and you said you want them taken on block. So, Deputy Morell, you'll have your chance to respond, of course, Minister. Deputy Morell.
Thank you, sir. Having read the scrutiny comments and reflecting back on the debate a month or so ago when these regulations were first introduced. I had a great sense of unease then, and I maintain that sense of unease today. At its heart, what worries me is that we are effectively taxing some, I use that word in its wider sense, taxing through the social security contributions some of the more vulnerable members in terms of economic vulnerability of our community. And if I could say an example is quite simply, if you're earning £15 an hour, you work for 8 hours. Previously, that would have been not subject to social security contributions. That's an earning of £120, but now the last £20 will be subject to social security contributions. So people who are not earning large amounts of money will be subject to social security contributions when previously they weren't. That seems to me to be a very likely outcome of this change. Now, what concerns me above that, so I'm concerned that these changes are adversely affecting people who are above income support levels, but as a family, as a household, but not enough to give them a comfortable living. Beyond that, I then become very concerned when I think through that original debate and I think about the things that were said then by the minister, and things that were said included things such as, we have to get this through because employers are expecting it. We've consulted with employers and they're expecting the change to take place on the 1st of January. On top of that, we had another reason, which was which has been given in the scrutiny panel report, which is computer systems have been changed, and as a result of the changes to computer systems, we need to change the law. I'm frustrated with myself, sir, because there was a third reason also given for the change, and I can't off the top of my head remember that right now, which is frustrating. And so we have had different reasons given by the minister for this change. And the truth is none of them stack up except the final one, which is espoused in the scrutiny comments, which is there was a change of computer systems in Revenue Jersey. The computer systems can't do it the way we used to do it, therefore we need to change. And as the scrutiny comments make abundantly clear, this was an officer level decision which requires a change of statute, and that decision was taken without having referred to this assembly to ensure that that change of statute should happen in advance. I'll say it again, I am here in my view to defend this assembly. This is not an appropriate way to act. It is never an appropriate way to act, to essentially make the landscape or change the landscape in such a way that the states are then forced, because that is what is happening today. We are being forced to change the law in order to accommodate changes that are happening within departments to their computer system. As a result of that change of the law, I do believe some families in this island will be out of pocket. I find that, to be honest, outrageous. I think it's incredibly embarrassing. And I do expect to hear the Social Security Minister give us a very clear reasoning as to why this has happened. Because I can also say that I have spoken to employers who had no idea this change was happening on the 1st of January. So the consultation had not got to all employers. All employers were not expecting this change, as the Minister told us in that first debate. And here we are. The reason we are changing this law is for no other reason than they have changed software systems in Revenue Jersey. That's the whole reason we are changing this law. It's wrong. It's very wrong. It will mean that some more vulnerable households and families in this island will lose money as a result. So, sir, it is very difficult to vote for this, knowing that those are the reasons behind it. It just feels so very, very wrong. Thank you, sir.
Deputy Pampton.
Thank you, sir. I rise to speak on behalf of the Health and Social Services Scrutiny Panel as the main responder in this debate, and to remind everybody that as I am Vice Chair, but I do speak on behalf of the panel, and would like to thank our officers for their work, especially given the many work streams that they currently have. I also want to thank the Minister and the department. As I mentioned at the last state sitting, our panel has always had a good, constructive relationship with both the ministers that we hold to account, and we have now arrived at a better place than when we started, as the previous speaker was alluding to. As States members will recall, sir, when this debate commenced on the 15th of September, we provided a comments paper to Assembly member colleagues, which at that time raised our concerns. We had some concerns on the reason and the thrust of the proposition being brought. Initially, we raised the issue, also saying that had we had more time, we may and could have done some further work highlighting this and other concerns on some of the data behind the original proposition. This was then echoed by other members during the in-principle debate, as we know was nearly referenced back. However, as we stated, sir, we called the proposition in to see what further work we could do for States members in the time for the next debate, which we did, and presented that comments paper as we promised we would do on the 29th of October. Following confirmation that the debate after we did that on the draft regulations was going to be referred to this state sitting, our panel was invited to a joint briefing with the Corporate Services Scrutiny Panel from the Minister for Social Security and government officers from Revenue, Jersey and Strategic Policy, Planning and Performance. That took place on the 3rd of November. It was a pleasure to attend alongside our fellow scrutiny members, and Senator Vowler. Personally, I'd like to just add it has always been inspiring to me on her scrutiny work and her approach to scrutiny and holding government to account. However, during that meeting, based on our research and subsequent questioning, it was confirmed that there had been already a commitment to amending the minimum earnings threshold from an hourly to monetary calculation, as the previous speaker has already stolen my thunder, by way of software changes made working with the Revenue Jersey computer systems prior to the draft regulations receiving approval by the States Assembly. So both panels were disappointed that these commitments were made prior to the States Assembly scrutiny process, debate, and then approval of the draft regulations. We must hold this sort of thing to account every time. We must always uphold the democratic process at all times. Regrettably, the panel concludes that the Assembly was then put in a very difficult position during this whole process because of these changes that have already been made in advance. But we did welcome the commitment by senior officers at those meetings to review this situation. However, sir, the panel is pleased that the Minister said that she would revise the threshold of the minimum earning thresholds from that which was originally proposed in the report accompanying P79/2021. The panel notes that the Minister will now set the minimum earning threshold at £434 per month or £101 per week, equivalent to 8 times the 2022 minimum wage of £9.22 plus an additional 36%. The Minister is also committed to lodging a further amendment to the Social Security Jersey Law 1974 for debate by the State Assembly by the end of February 2022. The amendment will seek to ensure that the automatic uplift to the minimum earning threshold is protected and is not subject to the will of the Minister for Social Security by order. The Minister asked for the panel's input, sir, regarding the 2 possible options to uplift the minimum earning threshold in future. Following some consideration by the panel, we decided that an uplift in line with minimum earnings would be preferable, and we are pleased to see the Minister's proposals today and in the addendum. A copy of the panel's letter to the Minister is attached to our comments paper that was circulated to members, and our comments paper. All of this is available, of course, on our website. In conclusion, sir, the panel is of opinion that the debate about P79 should have been about the principle of whether the introduction of a minimum earning thresholds of monetary value was the right change from a period of 8 days, and if so, what the appropriate monetary value of that threshold is for the employees at the lower end of the wage scale, with proper consultation, as again, the previous speaker alluded to. As stated, one of our original concerns, sir, was that setting the minimum earning threshold at 8 hours minimum wage would negatively affect people working at the lower end of the wage scale, or those with second incomes. Some of our short, timely, targeted survey work indicated this, showing, among other things in that data available to all members and the public, that in the numbers of those people who responded to our survey, it was women who would have been impacted the most. The panel maintains the point that there was just not enough up-to-date data to adequately assess the current situation at this time, and that similar impact on islanders needs to be better supported by more up-to-date data as much as possible. We know that the 2021 census data will start to come through next year, and we urge as much that can be done to please be done so we can really have a grip of what islanders are going through right now. We also acknowledge further information supplied by the Minister's officers and the independent input provided by Statistics Jersey, as well as other helpful contributions to the panel's work. While the panel still has concerns, we accept that the Minister's new approach in setting the minimum earning threshold, as confirmed to the panel by letter to us and the addendum presented today, that it seeks to address some of our earlier concerns about the negative impact on low-wage earners. The commitment from the Minister to increase the weekly minimum earning threshold from the 1st of January 2022 will provide an improvement for the islanders on the margins of the contributions threshold in terms of their take-home pay. And as the Minister has stated also, that given the importance of the new threshold, the Social Security Minister will return to the States, as I said, by February 2022 to set the value and annual uplift in the Social Security Jersey Law 1974 through regulations. So we have asked for the Minister, and I know she will commit to giving sight to that to the scrutiny panel in as much time as possible. So what this experience has shown and proven once again is the importance of a proper impartial scrutiny process acting as a critical friend to government. We had concerns, and in layman's terms, something was not sitting right. We did all that we could do to investigate and bring those concerns. And through that process, States members engaged, and we are where we are today. The heart of our work, sir, was the islanders we all represent, and for those that this change, if it hadn't been amended as it is presented today with the Minister's addendum, could have impacted some of our islands community. The data of the challenge was worthy of the challenge, and especially taking into consideration the impact of the pandemic currently, Brexit, the current rising cost of living, and the rise of inflation more so than ever for the year ahead. Also, as I have mentioned, sir, when we got down to it, there'd been an assumption, a commitment to amending the minimum earning threshold from an hourly to monetary calculation by way of software changes made to computer systems prior to these draft regulations receiving approval by this States Assembly. The mistake was regrettable in an effort, I understand, to be efficient, which we also do accept. But again, we welcome the responses by the senior officers on this point. The panel thanks the ministers and officers for the constructive discussions that have taken place. We're pleased to note that the outcome of the panel's work raised in the scrutiny process. We wish we'd had done it a different way, but we are where we are. There is more detail on our comments paper reports and online to assist members in their voting today, and I hope that proved helpful. Thank you, sir.
Thank you very much, Deputy. Does any other member wish to speak on the regulations in second reading? No other member wishes to speak?
Yes, I do.
Deputy Ward.
Thank you, sir. So I'm speaking, I'd like to, some of the points that have already been made are quite important, and I'm still ill at ease with this. And I suppose there is a context to my being ill at ease, which is that initially I did bring back a reference back that was fought against so strongly by the Minister and others. But then when we came back to the Assembly, the same arguments were used to delay the bringing of this piece of work, and that seems to me as a huge contradiction, and it doesn't create faith in us when we're looking at the implications of this. So I'm not clear at all of how this will affect the lowest paid in our communities. And a scenario is there are so many people who are working full-time, 35, 40 hours a week, perhaps on or around the minimum wage you pay, plus their social security contributions. But because of the huge expense of living here, and particularly if they've got a family, they may be working a second job for a few hours a week. And previously it was less than 8 hours, and that hourly rate for that less than 8 hours could be a reasonable rate. If somebody was taking on a cleaning job, for example, and there are so many who do that as a second job, is one example, who then wouldn't be pulled into the extra social security contributions, for which, and I'd like to be proved wrong on this, which there is very actual little benefit long term in terms of the pension received for those small extra contributions made now, but have a significant effect on the income of that family now when they need the money week on, week out. And that's one of the concerns that I have. And I'm worried, and we don't know. Again, we just simply don't know whether this will drive down the hourly rate of some workers who, you know, an employer will say, well, look, you know, if you earn less than £100, we don't have to bother with our contributions, you don't. So actually, you're better off anyway. So let's just pay you a little less, which is exactly the opposite direction we want to go in, to have a high wage, high skill, high value economy, which is the only type of economy that's sustainable in the modern world as we move forward. So I wonder whether in the rush to make this more convenient for a piece of software, and I don't know why we're serving software and software is not serving us, to be quite frank. I really don't understand that. I thought so that software was written for our uses and not the other way around. But yeah, what do I know? I'm not a software engineer. In the rush to do that, I think there are unforeseen circumstances which we've not accounted for, and still I still feel ill at ease. I'm reassured, and I'd like the Minister to completely reassure the Assembly that the rise in the limit of this would be on the average wage each year. So this £100 limit wouldn't stay static for the next 10 or 15 years like so many allowances do on this island, and so many things do on this island, and thus become increasingly more punitive for those working with lower incomes year on year on year, which is a real concern for me. And so I would still like to have seen this withdrawn, taken back, and come back with a lot more work done on it, so that we can genuinely understand the long-term implications of this, because I don't think we know. And the argument for convenience does not sit well with me. However, I'm pleased to see an improvement in the limit itself. So I'm still not at ease with this, and I'd like some reassurance that we do know this isn't going to disproportionately affect those in the lowest incomes who can least afford it. Because if that is the case, I would not be supporting something that does that in our society. Thank you, sir.
Everyone.
Thank you, sir. I wasn't going to speak, but prompted by the previous two speakers, I'd like to put a couple of things on record. Firstly, I am concerned about the political accountability of Revenue Jersey. Clearly, there's been an error here that where part of our government procedure, a vital one, our tax raising body, has seen this as purely an administrative matter. But the reality is that taxation policy is a vital part of public sector management and policy setting. The way we set priorities, different groups in society, the way we plan those, and that means that in future, I think we're going to need more. We faced, or they say we, it won't be I, it'll be other members in the future, I hope, will start to look at broadening our tax base. And that will mean political choices. And one of the things I personally always have a view about is healthcare, where I know in our sister island, that they have arrangements to make sure that people will pay a contribution to that. So I'd like the Treasury Minister to deal with that aspect and let us have a report and her thoughts on the best way in which we can have political accountability of that body, because it isn't just a straight executive structure. It's not a straight operational matter as if it's just minor. It's of huge importance. But I do accept at face value a mistake was made. Perhaps I'd like to know the reasons a bit. Was it communication failures or what in our one government system? And then, of course, our Social Security Minister is the minister who is having to bring this. And I can see the position that she has been put in, which is very uncomfortable. And I'm sure the minister won't want to, won't want to go into all the ins and outs of what brought that situation about. But nonetheless, I think what we're now offered is at first read, seems to me a pragmatic solution. Because my particular concern about the social security issue was that this new arrangement was triggered at the level of a minimum wage, and I just could not understand why that was being done. To me, you know, it was just unarguable that we should be striving and adopting policies to help the lower paid and have a living wage. Now, my understanding, and I hope I've got this right, and if I've got it wrong, I rely on the Minister to be back on track or other members to point it out, is that the pragmatic solution we're offered now is that starting point for that rate will be £100 for an 8-hour work period. That's the threshold level, which does, I think, work out a minimum wage plus quite a decent add-on of 38%, I think the reports said. So that seems to be a pragmatic choice. I tend to agree that with Deputy Ward, the position of people that do second jobs and third jobs and so on, the effect on them is unknown. I think the reports are honest enough to say that. We don't actually know. But we seem to have come to this point where, due to what went on within government, we probably have to go with the pragmatic choice and support the Minister, because I think, you know, one doesn't want to make a drama out of a crisis, as it were. Thank you, sir.
Thank you very much. Deputy Senator Valwa.
Yes, thank you, sir. I speak following Deputy Ward's comments. I think it's important to try to understand the numbers that sit behind some of these discussions, and the original proposition referred to £66 per week. Deputy Pamplin quite clearly set out the role that scrutiny have played since the last debate. We're now moving to £101 per week. So if we equivalise that against the 8 hours, you're looking at £8.25 as per the original proposition, so just over £12.50 per hour if you equivalise that to the 8 hours. And I think that's important to make that connection about the decision making we're making in the States Assembly. But I also have to say that one of the concerns that I do have is this issue of the software dictating what we should or shouldn't be deciding on what is best for our community and best for the public. And we have to be extremely vigilant of this going forward with regards to modernisation and digital and the use of the cloud-based app. And you will see this with regards to CNAG report and the recent Public Accounts Committee hearings that we've had. So I would just suggest going forward being extremely vigilant on the responsibility of a national parliament being first and foremost informed in the appropriate manner before such decisions are made. But finally, sir, in what I'm going to say to this proposition, I'm just going to say thank you to the Minister for hearing the concerns of scrutiny when we had our follow-up discussions around the order making powers. And so I think it's really important to make this point, especially as chair of the Democratic Accountability and Governance Subcommittee of PPC, in that members have to be extremely aware when laws and regulations are being changed to allow ministers to make decisions that might have originally been made by the States Assembly and consider whether it's appropriate or not. And in this particular respect, I'm grateful to the Minister for listening to us in understanding the fact that the regulations need to be changed, and I would like to hear an absolute commitment from the Minister in this debate that amendment will come forward, that there will be a regular uprating of that weekly amount for the minimum earnings threshold, so that it just doesn't depend on whoever is minister at the time, or it has been forgotten for so many years, as Deputy Ward referred to. So I am grateful for the minister recognising that, and I do look forward to seeing that amendment coming forward. Thank you, sir.
Thank you, Senator. Senator Ferguson.
Thank you, sir. It seems to me we're effectively giving with one hand and removing with another. And at the same time, we are adopting policies which will significantly increase the demands disproportionately on the income of low-income families. This is totally dysfunctional and uncoordinated. It really is time that the Council of Ministers starts to coordinate its activities better. Thank you, sir.
Does any other member wish to speak on the regulations in second reading? No other member wishes to speak? Then I close the debate and call upon the Minister to respond.
Thank you, sir. And I'm really grateful to everyone who's spoken, and I'm ever so grateful to the Assembly for letting me not take this last time and actually speaking to both the Health and Social Services Scrutiny Panel and Corporate Services Panel and bringing them up to date. I absolutely agree with Deputy Morell. We should not be in this place. I take full responsibility. A couple of years ago, Revenue Jersey were tasked to do a big piece of work, and from January they will collect social security contributions, tax, monthly, and it's to help us know better information, but it also helps the employers out there, and it should help the employees as well. Obviously, this piece of work, I think, started when in 2019 with P109. There, as it went on, the piece of kit that was bought does not recognise hours. So, in the background, sir, somebody thought, oh, there's a small there's this. Goes back to when Social Security was introduced. Oh, if you were working a few amount of hours, under 8, it's not 8, it's under 8. If you work 8, you pay. You don't pay any contributions. Now, there's not that many people that do that, and I'd like to reiterate as well about the low income. Yes, people on, if you're an income support family, it won't affect. If you're a pensioner, it won't affect. And if you are just doing the one job around that £12 an hour and you don't go over the £100, it won't affect. But there is a downside to not having any contributions at all, because you don't pay into anything. You don't get parental benefits, you don't get sick benefit, and as you get older you don't get an old age pension, not in your right. So, but I'm not changing that, and it's definitely not to do with finding some revenue for the Social Security funds. It's probably negative. I do understand. I was saying, oh, it was so-and-so's fault. At the end of the day, sir, this piece of legislation comes under the Social Security Minister. I had a really, really good meeting with Scrutiny. I am bringing back the regulations in February I'll say that to Senator Walvar, because it's got to be done. And it will be uprated every year by the minimum earning level. So it won't sit there. And if anybody wants to change it after me, sir, it will have to come back to the Assembly. I thank Deputy Pamplin for his comments, and Deputy Young, I understand that we're not trying to hit the lowest paid. It's one of those things. The scrutiny, again, my scrutiny panel, Health and Social Services, did their review, and I understand again what Deputy Morell is saying, but a lot of people out there do know. They've been testing this. Unite the Union are very happy with this because they think it will be much easier to have a figure than it is, because it's unfair. Some people are are being paying contributions under the 8 hours is how the employer finds it so hard to understand. And the Chamber of Commerce thinks it's a very good idea, and most of their people already know that it's happening. To say, I can't apologise enough, sir. It's been 2 years coming, and this should have been done. It should have been done in principle a couple of years ago. When actually the kit was bought, and then they've said to the employers out there, this is the kit you need to tell us once, tell us monthly, collect social and revenue, collect social security contributions as well as tax. I don't know, but it's happened, and it just really does not say the kit does not understand the hours. So it is, as Deputy Pamphlet, I will coin his phrase, I'm sorry again, but we are where we are. And I think to make sure people will be paid in January, we have to make this change, because the kit has told them to. I'm very sorry this has happened. We're taking steps it shouldn't happen again. I can't apologise enough, sir, but I have to maintain the regulations and ask for the appeal.
As called for, ask the greffier to place a vote into the link. The vote is on the regulations in second reading. The vote is in the link. Ask the greffier to open the voting and members to vote.
I register a vote. Can't.
Go on.
So Deputy Ash here, poor.
Sorry. Deputy Ash, is there any reason why you can't register that vote into the chat?
Only that I can't get into it at the moment, sir. Like yourself, I'm a bit of a Luddite, but I am trying to remedy it, and we'll reboot myself in a minute.
Well, very well. I'll take that as your indication of a vote then. Very well. Members have had the opportunity of casting their votes. Just vote in the chat. Well, let me just count up the votes in the chat before we close the voting elsewhere. Members have had the opportunity of casting their votes. Ask the greffier to close the voting.
Deputy Rennick doesn't appear in the chat. I don't know if that's my system.
No, the Deputy of St. Juan is singularly absent from the chat. Of course you can, yes, given that you had indicated that you had voted, so. Right. Ah, yes, there we are. Well, I'm afraid we can't change a vote that's registered when I've closed the voting. So we've had a ring binder moment. We might have had a bracelet moment, but the regulations have been adopted in second reading. 28 votes pour, 5 votes contre, 1 abstention in the link, and a further 7 votes pour and 3 votes contre in the chat. Very well. Do you propose the regulations in third reading, Minister?
Yes, sir. I propose the regulations in third reading, and thank everyone who voted. Thank you.
Is there any, are those seconded for third reading? Does any member wish to speak in third reading? If no member wishes to speak in third reading, then I ask the greffier to place a vote into the chat. And I open the voting and ask members to vote. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The regulations have been adopted in third reading. 30 votes pour, 6 votes contre, no abstentions in the link. A further 6 votes pour and 1 vote contre in the chat. Two votes contre in the chat, I beg your pardon. Very well. We come on now to the draft COVID-19 enabling provisions, amendment number 3, Jersey law, P83, lodged by the Minister for Health and Social Services. For the purposes of this debate, the main respondent is the chair of the Health and Social Security Scrutiny Panel. Now, this debate is resuming following the decision of the Assembly to refer the matter back to the Minister on the 8th of October, and in accordance with Standing Order 86B, Minister, you may propose the proposition afresh if you wish to. You wish to propose the principles again? Very well.
Thank you, sir. So following the reference back made by Deputy Tadier during the initial debate on this draft law on the 8th of October, I have submitted an addendum to the proposition, which I hope all members will have had an opportunity to consider. Members will see that it seeks to answer the questions posed during the debate to the extent that the government is able to do so. States members' briefing was also held last Thursday to assist with any other questions that may have arisen. I regret, sir, that Deputy Tadier, I don't believe, is in the Assembly at the present time, and our thoughts are with him. Members will see, sir, from the addendum that we have explained the issues with modelling the future spread of COVID in some detail. I'm sure members would have preferred to have a simple outline as to the anticipated future path of the pandemic, but I'm afraid that is just not possible given the unknown effects of all the various interactions between the different factors in play. Even larger jurisdictions such as the UK, with far greater capacity to conduct modelling exercises, do not pretend that they can make anything other than very short-term predictions, and the complexity of such predictive work increases with every new mitigation in place. In particular, because the vaccine programme has been immensely successful in reducing the spread of COVID, it has had significant effects on modelling efforts. So although we're not in a position to make any meaningful projections as to the precise severity or timing of peaks of infection, we can draw some general assumptions on expectations for winter based on currently available data, past experience, and the work done in other jurisdictions. The current projection is that we will see a rise in COVID infection over the winter due to the usual changes in people's behaviour, primarily because we will spend more time indoors in close proximity to each other. It's likely that the usual patterns of intergenerational mixing resulting from extended families coming together over the festive season will also see a spike in cases after some delay, but the effects of this cannot be effectively modelled. However, drawing on the analysis from the advisory body, the Scientific Pandemic Influenza Group on Modelling, or SPIMO, in the UK, we anticipate that due to the vaccination programme, overall levels of COVID hospitalisations will remain significantly lower than in January 2021, unless we see both a rapid increase in transmission rates and unexpected waning of vaccine protection. This does not mean that we should be blasé about the risks over winter, as all of the positive drivers of COVID infection are also likely to cause an increase in the levels of infection of other respiratory diseases as well. And that could create confusion around whether people have COVID, as well as putting additional pressure on our healthcare system. Therefore, the best available information at this time indicates that while the situation is highly uncertain, we may see increased infection over winter, and so there may be a need for additional measures to be introduced in response. This uncertainty and the resulting need to maintain vigilance are the rationale for maintaining our capacity to introduce preventative measures into 2022. That is why I'm asking the Assembly to extend this COVID enabling law, following the decision to extend the suite of COVID prevention powers it has already taken on the 8th of October when it approved P84. Those were the detailed regulations, such as those relating to testing and isolation, the taking of contact details in venues, and many regulations which are presently suspended, but they are still available for use if it became necessary. Mask wearing would be one example of that regulation, presently suspended, but still available. But this proposition, P83, concerns only the extension of the COVID-19 enabling provisions, Jersey law, to the 31st of July 2022. This law is a short law. It effectively is the Privy Council permission to this Assembly to make emergency laws to protect public health without the need of the sanction of the Privy Council because of the emergency situation and for a limited length of time. The function of the enabling law is to ensure that we retain the capacity to manage our legislative framework, and that enables decisive action when it is needed, but it also restricts islanders' liberties as little as possible. Now that P84 has been adopted, the duration of the legislation, the detailed regulations, run to the 30th of April 2022, which falls beyond the end of the current enabling law, which in fact ends a month earlier on the 31st of March 2022. So the enabling law should overlap the other legislation, and it currently does not. And as members will be aware, if the enabling arrangements were to expire, no new emergency regulations and no order under the existing regulations could be made after the 30th of April, with immediate effects on the control of COVID-19 if we needed at that time still to exert controls. So during the previous debate, there appeared to be some consternation around the extension of the enabling law beyond the election. And I apologise that the accompanying report did not sufficiently address that issue, and I will attempt to do so now. In all previous arrangements for the extension of our COVID legislation, and we've extended 3 times, the regulations have been extended either in active form or extended when suspended but still available. And the enabling law has also been extended at the same time. But in every one of those cases, the enabling law has been extended beyond the duration of the regulations. In today's case, it is proposed we extend the law to July 2022. And it's necessary to extend to that date because there is a built-in delay to any decision around any further extension of the law. If there is a desire to further extend the COVID legislation in March or April next year, and I recognise that there may be or may not be, then the Assembly can vote on the regulations and they come into almost immediate effect. There is no intermediate process involved, and the change follows automatically on the timeline specified by the regulations. But where the Assembly votes on an extension to the enabling law, the situation is different, as it's a change to primary law. Although the legislation only consists of the substitution of one date for another, it must be passed through the Privy Council process for royal assent, and then passed back to the island for registration in the Royal Court before it can take effect. We cannot be absolutely certain of the time needed to take those steps. So although the speed of gaining royal assent has been increased in recent years, there is precedent for it taking several months, and it is dependent on the date on which Privy Council meetings happen to fall. The Council of Ministers has taken the position on each occasion that it's appropriate to bring the enabling law to the Assembly at the same time as the detailed regulations. This is intended to allow members to take a view of the entirety of the pandemic legislative arrangements in the same session, and to avoid the confusion that would arise if we brought the enabling law extensions separately. Previously, that was not a point of contention amongst members, but it happened that on 8th of October it was, so the reference back was made, and today we are debating only the enabling law, which extends a date, and not the detailed regulations in themselves. So I've explained about the need to go to the Privy Council and that delay. So to accommodate that delay, the enabling law runs for a longer period than the regulations. And for safety and to avoid unfortunate accidents, the enabling law usually runs for about 3 months longer than the regulations. So there's therefore no intention to allow the COVID legislation to proceed over the election period without another debate in this Assembly. The regulations themselves are timed to expire at the end of April next year, before the election. So if the Council of Ministers consider the situation requires a further extension, then the debate on that proposition will need to take place before the end of April. And whatever the Assembly decides at that time, it will not be possible to have any of the COVID regulation in place beyond July 2022 without extending the enabling law. So by necessity, members will also be required to consider an extension to the enabling law before the end of April. At the actual moment on which enabling law changes will be determined by the Privy Council meeting dates, hence the law running for several months longer. But any decision in this Assembly on further extending the enabling law will be taken before the end of April. So I'm sorry, this is rather complex and detailed in procedure, but in summary, sir, only by allowing the enabling law to run longer than the regulation can we allow the Assembly the chance to extend it in April next year. The July date does not prejudge any decision of the Assembly, and nor does it indicate that any restrictions will be in place at that time. If the Assembly does not agree to extend the COVID preventative legislation before the end of April, or if the Council of Ministers doesn't propose such an extension, then the regulations will simply fall away at the end of April, because that is what we've said would happen in the regulations. And if that happens, the enabling law will remain in force on the background, but it will not have any effect. All it does is to allow the Assembly to make regulations that act as primary law without needing to go through the royal assent process on every occasion. That power would remain in force until July, but nothing could be done with it except to bring regulations to this Assembly. So that was perhaps the first issue that was raised by Deputy Tadier. The other two I can deal with more shortly, I think. The second issue raised in his reference back was the question of the human rights statements. And I hope that the addendum I've lodged explains that the subject of this immediate proposition is a change in the date of the enabling law, which is currently in force. So simply by changing a date, that does not in itself create an issue of human rights. The underlying consideration around human rights are addressed in the statement of compatibility for the original proposition passed in 2020, and there was a link to that in the accompanying report to P83. And likewise, issues of financial or manpower implications under Standing Order 21 are not engaged by us changing the date. There are, of course, resource issues arising from the pandemic response, but these are identified in the normal way in the budgetary reporting of government. No one's in a position to say at this point what the costs will be over the next 6 months due to the uncertainties I've referred to. Deputy Tadier also raised in his reference back what engagement there had been with industry. Ministers have heard from businesses directly and through groups established for the purpose, as well as arm's length bodies. Businesses are fully aware of the contents and the effect of the planned winter strategy, and that's been discussed with them in a business group established under the name of Safer Jersey Group. And recently, I've been pleased to work with business in keeping Jersey in business. Ministers are fully aware of the economic effects of retaining COVID controls, and those effects are taken into account whenever a decision is made. Sir, I hope that between the addendum published last week, the States Members briefing, and this rather involved speech today, I've been able to provide members with enough information to continue this debate on the enabling law. But I will, of course, try and answer all other questions, sir. Thank you.
Thank you very much, Minister. The principal seconded.
Yes, sir. Yes, sir.
A question has been raised in the chat by Deputy Ward as to whether it's appropriate to remove masks more generally in the Assembly. I gave a direction that masks should be worn because we did not at that time know how many members were going to come and be in the Assembly. It occurs to me looking around that with a little bit of movement, it would be possible for everyone to be at least 2 meters distanced if they wish. And I will be minded, unless members feel strongly to the contrary, to make the wearing of masks optional from now on, given the temperature and the discomfort. I'm not indicating, but I wonder if any member would like to, any member in the Assembly would like to comment or make any observations to the contrary.
So I wonder if I might.
Yes, indeed, yes.
So I do wonder whether we really ought to be setting an example with the numbers going up. I'm sitting here, I'm pretty uncomfortable in this mask, but I do wonder whether as States members, we really ought to set a good example and keep them on. It's my own view.
Thank you very much, Steve. Does anyone else have any observations to make on Contab Simralad?
Likewise, sir, I think we do risk criticism as I don't know if this sitting is broadcast.
It is broadcast in the normal way, and I'm not urging that we do, but it's been raised in the chat as a possibility, so I just wish to give people the opportunity of considering it.
So I raised it simply, sorry.
Yes,
So simply to say that I share the view of the 2 previous speakers.
well, in which case I think that does appear to be, and Deputy Ward raised it perfectly reasonably within the chat. I've canvassed the views of members.
Genuine
Those
question.
moves are fairly clear, and we will proceed as directed with the points well made. Very well. Does any member wish to speak on the principles? Oh, one moment. Firstly, to take these things properly in order, Deputy Ward, you had a question for the Attorney General, I believe.
So yes, I was going to just ask, in a briefing that we had, I did ask a question that was answered by the officer very well, but he was going to come back to us and I haven't seen that. I may have missed it, so I apologise if I have. The the law is extended until the beginning of August, and I understand if the regulations drop away, then effectively we have a law in the background with no regulations. But my question is, because the big difference is that we are going to an election campaign and a time of, I don't know if it is called purdah here or not, that time when there isn't an assembly sitting. And I think it's a question for the AG. What is the mechanism by which, if ministers who would still be the minister believes that there are some regulations needed at a time when we are all not in this assembly because the law is in the background, would that require a recall of the assembly? And I think just the advice from the AG on where we sit with that law being in the background with possibly nothing there. I think it's important for us to know about that for that specific time around election time.
It may assist if I say, Deputy, I'll call upon the Attorney General in just a moment. On my recollection, the law provides that I am in a position in a state of, if there's an urgent reason to do so, to call a meeting of the Assembly. I think that's the case. But Mr. Attorney, do you have anything you wish to say?
It's the Solicitor General.
So, yes.
Just to make this point, the only power that the enabling law creates to enact regulations is a power that is given to the State's Assembly. It's not given to a minister or any individual member. And therefore, if there were a need perceived by a minister to resurrect or reenact regulations under the enabling law, there would have to be an emergency recall of the Assembly to vote on that. It could not be done by a minister on his or her own initiative.
Thank you very much, Mr. Solicitor.
Thank you, sir.
Senator Farwell, you had a point of order?
Yes, thank you, sir. I'd just like to get clarity from yourself, if possible. I listened intently to the Minister's speech. As my understanding of the reading of the proposition, we would be agreeing to the extension of the enabling law to the 31st of July. What he stated in his speech suggested otherwise, but I just would like to seek clarification from yourself as chair as to what it is we're actually agreeing or not agreeing in this States Assembly debate.
You're agreeing one thing only in this debate. If you pass this enabling provision legislation, you will be extending the effect of the enabling provision laws to the 1st of August of next year. In other words, it would end on the 31st of July. That's the only thing that would be agreed. Nothing else would be agreed. The specific underlying legislation, which has been created under the umbrella of the enabling legislation, falls to be considered on other dates and on other occasions.
Okay, thank you very much, sir.
Very well. Senator Moore, did you wish to speak?
No, sir, that was
the
in
other.
relation to the masks.
And that might be Deputy Young. Did you wish to speak, or was that in relation to the masks?
So if I may speak.
Yes, of course.
Thank you. So I think absolutely this is essential that we have this in place. There's no question. None of us, I think, if one reads the addendum, what comes out loud and clear is uncertainty. None of us know at all. But the models are, they are models, but there can be no predictions. There's so many variables, and not to have this piece of legislation when we're told these social measures have been critical, probably more effective compared with vaccination in actually controlling this disease. So we need these tools. My question to the minister, I'd like to be assured on this, because it seems to me that as we go into the next year, we are really squeezed for state sittings, really squeezed. I myself got real concerns about with the island plan. We're going, what that will probably take up a huge amount of time in March. We've got one sitting in April, as I understand it, before we hit the purdah date. And then, of course, we're going to go through a massive period of uncertainty about formulation of the new states, who's in it, or what have you, right until the 22nd of June. And yet this law here We're only, so I'd like to be sure, the Minister said, we don't know when the Privy Council will approve this. And of course, until we get the Privy Council approval, we won't be able to bring the regulations here. So I want to be sure that we've really got contingency plans to make sure we have the capability to be able to manage this situation in the future, sir, because I'm absolutely 100% behind this, but I do wonder, is the date even enough? But it is what we got in front of us. That's the choice we have. That's the only choice. But I'd like some assurance from the Minister, please, that they're on to this.
What I might be helpful to remind members that, of course, when the COVID legislation was passed, it was passed during a lot of meetings specially requisitioned outside the normal run of states meetings. And of course, there is no problem with a requisition suitably backed to create states meetings which are not on the list at the moment. I simply mentioned that as a reminder to members. There's been indication in the chat, I think, or elsewhere, that when members are speaking, they are breaking up. That might simply be one recipient who is experiencing difficulties. Could any members indicate in the chat whether they have problems listening, those who are not listening here?
Yes, sir, I have intermittent sound.
Well, it seems to be that the problem is not with everybody. So I'll just ask people to make sure that when they are speaking, they're speaking as clearly as they can. And if important matters are breaking up, then please would people indicate within the chat. Most people are saying that it's fine. So we will continue. Deputy Morell.
Thank you, sir. Sir, I don't like the extension. I don't want the extension. But I don't think we have much choice except to go with the Minister on this. And by saying that I don't think we have much choice, I don't mean that in a gun to the head or we've changed our systems and therefore we need to change the law kind of way. I mean that because the pandemic is forcing us into this. It is a lingering pandemic. We this year experienced a much better quality of life in Jersey compared to last year and compared to many countries around the world. For that, I'm thankful. And it has been easy. And to be honest, the Dean just reminded us that, as well, that when you're in a pandemic, we need to, as states members, kind of set an example as well in different ways. And precisely because people are forgetting that, I think. And it is very easy to forget from this island that we are part of the wider world, and the wider world is suffering in a pandemic. And another element which I have said before, and I'll happily say again, is that to date on matters of COVID regulations, the Health Minister has shown himself to be very happy to remove the regulations when they're not needed. I think that's an important, we've seen that demonstrated over the past year and a half. I think that's really important, and to be honest, it plays a lot into my thinking with regard to how to vote on this, because I think we can trust the current Health Minister to remove regulations when they aren't needed. As a slight aside, I don't think the competent authorities should be sitting in the way that they are now. I think that element of a democratic process needs to be restored to just solely the Council of Ministers. I think there is a lack of democracy in that. And I really think it's incumbent now on the Chief Minister to dissolve the competent authorities. It's looking a bit like a power grab now, and it really shouldn't. But as far as these regulations are concerned, I really think that we have to go with this. It's not what I doubt any of us here want to do this. But as we saw with protests this morning, that there are people who feel very strongly about quite understandably the taking away of people's freedoms. They feel very strongly for whatever reasons about the vaccinations. But we can see how vaccinations have protected this island to a greater extent. We are entering winter when people like me need to probably get a booster, and if I don't, I will be making the island slightly just a tad less safe as a result. So I will get that at some point soon. And but we don't know what will happen over the winter. Europe is experiencing rises in COVID infections. UK is experiencing rises in COVID infections. Jersey is experiencing rises in COVID infections. Thankfully, so far, they are not translating into hospital admissions particularly, and they are not translating into more deaths. But it is particularly the deaths element. We've had 80. That is 80 too many. And I don't want to see that number climb. So I think we have to place our trust in the hands of the Health Minister on this, as much as we don't want to, and that is in no way against the Health Minister. It's just we don't want to have to do this, but we really should, I believe. So thank you, sir.
Very much. Going to Albertson John.
Thank you, sir. And I would like to start by echoing the comments of Deputy Morell in terms of the competent authorities ministers. In my belief is the same as Deputy Morell's, and it should be stopped. I believe we're not in an emergency currently. It's about business as usual. I thank the Minister for the notes that he circulated. Unfortunately, the briefing on Thursday was scheduled at the same time as the scrutiny briefing on the hospital, so unfortunately I was unable to attend. But I note from those notes that the stack minutes are now being circulated to scrutiny, and I would urge him, as was indicated when we had a new chair who was less busy than the previous chair, that they would come out in a more timely manner, and for us to take the public with us through the winter, we need to rely on good, open communication, and having stack minutes in a timely manner, not 8, 9 or 10 weeks delay, will only help us take those people. Last week we were hearing about what was going to be happening with youngsters in terms of vaccination, and if we'd been able to read the stack minutes, we'd have been able to support those views in a much easier manner rather than question them. I urge the Minister once again to publish stack minutes in a much more timely fashion. Thank you, sir.
Deputy Pamplin.
Thank you, sir. I only rise because, to echo the words of the previous speaker, there was a very good proposition that came before this Assembly that helped in that regard. But on a more serious matter, I echo the words of Deputy Morell as somebody who has been leading the scrutiny of the health legislation throughout this whole process. This is a technical point, as the Minister has helpfully outlined, and I think the Solicitor General made a very helpful simplification of what this actually just is. It is essential that we recognise, though, of course, and I don't like to do it, but I need to take members back to March of 2020, because, as I've often said during this whole process, a crisis exposes everything. You cannot run and hide from it. And one of the things this pandemic has exposed, things that we do know about this island, our community spirit and the sense of the public doing what is required to look out for members of the society and help us in doing to keep this island going. The other, it did, in a more political sense, expose how out of date our public health law was, and led us to those emergency briefings back in under the dome of Fort Regent, which is now has the vaccination centre, which is quite mind-boggling. Gives you a sense of what's happened in a short period of time. But the reason why we're doing that and turning scrutiny around in a hoof is because the law wasn't fit for purpose. And we shouldn't, in 2021, as a democratic jurisdiction, be in that situation again. The public consultation about the public health law is so important, and the lessons learned from this pandemic, it's so crucial. And there are members of this public who are obviously quite rightly concerned, and it's good that they're being part of the democratic process. It will be for the next Assembly to continue that process, but we must not lose the lessons learned from the pandemic. We must ensure that these things are picked up because we shouldn't be in this position going forward. That's why we are today. It's a technical point, and I just wanted to make those points. Thank you, sir.
Very much. Does any other member wish to speak on the principles? Senator Valwa?
Yes, thank you, sir. Just on the basis of the point of order that was made and the comments that have been made so far, I think there is a duty upon the Assembly to hold to account the power that ministers hold, and this enabling law is going to be extended to the beginning of August. And so I feel I need to speak to challenge the health minister in some of the comments he made, and some of the comments I've heard from others in terms of what that means for the winter period. As I've understood it, June, July and August don't tantamount to a winter period. And also I would criticise and challenge the council of ministers around the strategies in which they are currently imposing and suggesting are the appropriate way to do things, but also arguing that having those powers and those enabling powers, but yet not using them, you know, it's kind of, sometimes I feel like when we're having these types of debates, we're kind of giving too much leeway without the appropriate accountability. And I'd like the health minister to explain, you know, at what point does it get to where some of the provisions which enable this enabling law are actually put into place? Because these are questions that the public ask many times, all the time. The impact on their business, the impact on schools, the impact on how to provide a service generally, especially when there's things like PCR tests or whatever that might be that's going on during a particular height in numbers that we see. Nobody knows the future of COVID, and this is managing an issue that we have. But sir, you've stated quite eloquently the provisions of the Assembly to enable an emergency meeting if it's deemed appropriate to do so. And so I would suggest that unless we have an appropriate strategy that suggests how ministers are actually going to utilise these types of powers in the appropriate fashion and in the appropriate way, then I'm not supportive of this enabling provision. And if they can create the evidence and the supportive data to suggest that we need it up until the 1st of August, then I'm more than happy to listen to that and see that information and be convinced otherwise, and have an emergency sitting if it's deemed appropriate. But sir, at this point in time, I can't support the proposition. Thank you.
Thank you very much. Senators, any other member wish to speak on the principles? No other member wishes to speak? Then I close the debate and call upon the Minister to respond.
Thank you, sir, and I'm grateful to members. Deputy Young spoke and expressed concern that we are being squeezed for state sittings before the election period. It remains the case that we can debate at any time whether we should renew the COVID legislation, but I think it's more likely to be during March or April. We will simply have to find time if the Council of Ministers believe that we need to extend beyond the expiry date of April, or if any member wishes to propose the extension of regulations. But we will be able to manage, I'm so advised, the process relating to the Privy Council. We will have that power to make regulations if the Assembly agrees today. That power will extend to the end of July. So any regulations that we might make in March or April would last to that end period at the very least. And if we debated a further extension to the enabling law, then it could go beyond. But it does simply depend on the circumstances that we will assess during the first few months of next year. So I'm advised that we do have capability to manage it. We'll obviously need further debates if the COVID situation warrants further controls, but the timing is all feasible. Deputy Morell made some excellent points. I absolutely agree with him and other speakers that we would not want to have this sort of legislation in normal times, and insofar as they create exceptional measures of control, I and other ministers will always try and make sure that that is only where it is necessary to prevent the spread of COVID. So some people have talked about a power grab. I simply don't see it as that. I'd prefer not to have these powers. I'd prefer to be a health minister concentrating on the delivery of health services rather than managing a pandemic, quite frankly, but it has arisen during our term of office. To the Constable of St John, I think I can only refer to my previous answers to written questions that he has asked, which relate to the process of minutes. It is not something that I have total power over, though I will speak again with the chair, but he chairs his independent advisory body, and there is a need for a process to be undertaken, which has been explained to the Constable. Deputy Pamplin referenced the out-of-date public health law that we have at present, which just would not have been adequate to cope with this pandemic emergency. So work is going on, is quite advanced on the preparation of a new public health law, which will probably come before the next assembly after the elections, but there will be a second stage consultation before then, and I hope all states members will engage as well as members of the public. Senator Valois, I quite understand this stance she is taking. We'd all want to have a precise model that tells us where we will be going. I've covered this in the speech, the addendum covers it. The reasons why it is just not realistic to set out a model and say this is the likelihood, because there are so many factors in play. So therefore, perhaps regrettably, we need to retain these powers to introduce measures to control the spread, to prevent harm to our community at short notice. But of course, those powers have been given to ministers by this assembly in the relevant regulations which were passed by this assembly. If any members thought that it was no longer appropriate to allow ministers to have that order-making power, then a proposition can be brought to that effect, or on making an order, that can be challenged. These powers are lent, I think, to ministers. They are not a power grab. This assembly has made the regulations under which they're made, and this assembly controls those regulations. We have issued a winter strategy. Senator Valois challenged us on our strategy. It goes beyond the scope of this immediate debate, perhaps, to go into a lot of detail, but it's written out there. We want islanders to take responsibility for themselves into keeping themselves and their loved ones safe as far as possible by adopting measures that they can easily take. The vaccination is the most important protection that people can give to themselves and our community. But in addition, to take the lateral flow tests whenever they are mixing with people, going into large crowds, to be careful about the occasions they do that, to wear masks in crowded indoor spaces. And so we're not using those powers. Our strategy is not to mandate those powers, not to bring the heavy hand of the law down at this stage. But of course, the position is constantly under review, and we receive advice from STAC and public health officers. So if, and again, our strategy references this, if it became necessary, mainly because of increasing rates of hospitalization that might imperil our health services, then it may become necessary to use these order-making powers and mandate, for example, mask wearing or other regulations. But we're not there at the moment. I really hope islanders will choose to protect themselves and make sure this island can get through the winter differently to what we did in last winter, because it can be done if we get good adherence to guidance. Otherwise, I thank all members that have spoken. I think I've covered all points, and I maintain the principles and ask for the appel.
As all for us, Greffier to place a voting link into the chat. And I open the voting, ask Greffier to open the voting and ask members to vote.
Sir Marcus Troy, voting link hasn't come up on my chat.
Right. Well, in which case, can't
Is
a vote for. Okay, I will note you as a vote for.
Thank you.
Members have had the opportunity of casting their votes. Then I ask the Greffier to close the voting. The principles have been adopted, 24 votes for, 8 votes contra, no abstentions in the link, and a further 9 votes pour in the chat and 1 vote contra. Very well. Deputy Lehegra, does your Health and Social Security Scrutiny Panel wish to scrutinise the matter?
Thank you, sir.
Very well. How do you wish to propose the articles in second reading? There are obviously only 2 of them.
Yes, sir, there's a very simple amendment. The first article extends the operation of the law until the 31st of July next year, and the second article is the usual provision for citation. So I'll propose them all block, sir.
Well, are they seconded for second reading?
Yes, sir.
Does any member wish to speak in second reading? No member wishes to speak in second reading. Then there shall be no debate, and ask the Greffier to place a vote into the link. Ask the Greffier to open the voting and members to vote.
Similar, sir. Marcus Troy, vote for.
Voting for. Very well. If members have had the opportunity of casting their votes, then I ask the Greffier to close the voting. The article has been adopted in second reading, 28 votes pour, 6 votes contra, no abstention in the link, and a further 6 votes pour in the chat and 2 votes contra.
We have the conch, please, sir.
Yes, the conch called.
Those voting conch, Deputy Ayer, the Conotab of St John, Deputy Higgins, Deputy Gardner, Senator Valois, and Deputy Doublé.
Very well. Do you propose the matter in third reading?
I do, sir, and may I thank members for their support and officers who've helped navigate a rather technical procedural matter successfully for the benefit of the island. Thank you, sir.
Are the articles seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? No member wishes to speak
Yes,
in
please,
third.
sir.
Chief Minister.
Sorry, sir. All I wanted to say is that just to reiterate the thanks of the minister to his team, and I'd like just to express my thanks to the minister as well for again bringing this forward to the Assembly. Can I just address one point where certain members have suggested we are in business as usual? Can I just reiterate, we are categorically still not in business as usual. It is not a routine process, and even now there are new factors and new variables that come in even to the present considerations. And that is why, sir, the present structure has served the island very well. We all would prefer not to be doing this and focusing on other things, but we will continue serving the island in the capacity that we do for as long as we need to, sir. But I do thank members for their support thus far, sir. Thank you.
Very much. So, does any other member wish to speak in third reading? No other member wishes to speak in third reading. Then I call on the Treasury Minister to respond. I beg your pardon, the Health Minister.
That's all right, sir. I certainly wouldn't want that job.
No, I might just choose anyone to respond. You're entirely whimsical about it, but no, upon the Health Minister to respond.
So I have nothing further to add. Thank you, sir.
Very well. I would ask, therefore, the greffier to place a vote into the link. And ask the greffier to open the voting and members to vote.
Marcus Troy, poor, sir.
Yes, Conotab. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The law has been adopted in third reading, 27 votes pour, 6 votes contre, no abstentions in the link, and a further 5 votes pour and 1 vote contre in the chat. Very well. The next item is the the Social Security Amendment of Law Home Carers Allowance Jersey Regulations P91, lodged by the Minister for Social Security. For the purposes of this debate, the main respondent is the Chair of the Health and Social Security Scrutiny Panel, and I ask the greffier to read the citation.
Draft Social Security Amendment of Law Home Carers Allowance Jersey Regulations 2000. The states make these regulations under Article 50 of the Social Security Jersey Law 1974.
Minister.
Thank you, sir. I would like to propose a small change to the Social Security law. home carers allowance is a contributory benefit from the Social Security Fund that is available to working age people who have given up paid work to care for a very sick or disabled person full time. Caring full time means over 35 hours a week, and we know that many carers deliver more hours care than that. At the moment, the law allows carers the choice of having earnings from a separate job up to a certain limit. Although only a proportion of carers do this, the regulations allow the Social Security Minister to make a minor change to the rules around paid work. It gives the Minister the power to set the rules by making an order, which I will do if these regulations are passed. Instead of setting the maximum earnings limit, I will set the maximum number of hours the carer can do paid work. They will be able to earn any amount within those hours. This change is likely to allow a small number of extra carers to continue with their previous occupation while still caring full time and receiving the home carers allowance. The current rules have a maximum amount people can earn. This is currently set at just over £170 a week. The figure is automatically updated every year. I've been contacted by a small number of carers who say this doesn't work for them because they are professionally qualified and can earn much more than this in one single shift. For example, sir, the carer could be a highly qualified nurse or an accountant or other professional job. People with these qualifications will leave their full-time job to care for their loved ones, but there is also a benefit for them to continue to take on a small part-time role. It is important that there is flexibility in the carer's benefit to allow the carer to keep in contact with the world of work. This could be very helpful if they may want to return full-time in the future. The opportunity to take on part-time jobs offers a social contact and mental stimulation. The change of routine and the welcome break from the full-time responsibility of caring. These are all examples that have been given to me by people actually doing the caring. If these regulations are approved, I plan to change the limit from a limit of maximum amount earned to the limit of maximum hours worked. I will set this at 15 hours per week. It is important that caring responsibilities are seen as the main role for the carer, and so the hours spent on other work is limited to no more than 15 hours in a week. I want to give all carers the option to work part-time if that is something they would like to do. Just to be clear, carers will never be obliged to work. This is providing an option for those carers to wish to maintain a small part-time job alongside their caring duties. Estimates show a small number of extra carers may wish to claim the benefit following this change, and it might cost the Social Security Fund around another £50,000 a year. I hope members will support this change. It's been quite a while coming. I actually think Deputy Southern was still my Assistant Minister when we had the first representation from the Parent Carers Forum. So I'll leave it there, sir. I'd like to maintain the principles.
Are the principles seconded?
Yes, sir.
Does any member wish to speak on the principles? If no member, Deputy Ward.
Thank you, sir. I just asked the Minister just to clarify. So we're moving away this time from a maximum that can be earned to a number of hours, which it does not have a limit on for those who are designated carers. And will that include those who? Actually, that is the main question, sir. And I suppose I would ask whether the computer systems can deal with that change, because we saw the opposite the other way around. And it's not as flippant a comment as it may seem, sir, because I think we have seen that there's issues with dealing with these things. It's just a reassurance that there's not going to be a problem for those who are take on those part-time jobs.
Any other member wish to speak on the principles? Deputy Hegarrow.
Thank you, sir. Yes, the panel received a briefing on this matter, and it makes sense that an individual is able to continue working in a profession that they are already doing, as opposed to being concerned about how much they are able to earn. So from my perspective, sir, I'm fully supportive of this change.
Any other member wish to speak on the principles? No other member wishes to speak on the principles? Deputy St. Won.
Thank you, sir. And I'd simply like to commend the Minister for bringing this forward. This is exactly the sort of flexibility that we need so that our workforce can be allowed to use their skills in an appropriate way for up to those 15 hours a week. Many of those caring will have skills in the caring professions themselves or in medical skills, and they will be a valuable adjunct within a flexible workforce. So this is a good thing that has come to fruition, in my view. Thank you, sir.
Very much. Deputy, does any other member wish to speak on the principles? If no other member wishes to speak on the principles, then I close the debate and call upon the Minister to respond.
Thank you, sir, and I'd like to thank Deputy Hegre and the Deputy of St One's, the Health Minister, and I didn't take Deputy Wards as flippant when I said these were never going to go together. These should have the 8 hours and this 15 hours were never going to go together. But please let me explain. The 15 hours is in the rules of the Social Security law, that you can care for 35 hours, get your full-time carer's allowance, and you can work 15 hours. Now, I've no interest on how much you earn, but they are going to be earning. All the people that have made representations are professional people. They can't do a shift and earn under £170. So it will be money. It will be money that their employer pays them. It will go through the new system as money. The hour check is for my officers to be assured that they're not working too hard, basically. We come to a compromise. We started at 12 hours. Some other, as I say, it's a very small amount of people, but I've tried to be as accommodating as I can. We've gone to 15 hours because, again, some of these people are going to be quite highly paid, but they also have the 35 hours of caring. So I hope that explains it, and I can fully understand where Deputy Ward was coming from, and I maintain the principles.
Thank you very much, Minister. I ask the Greffier to place a voting link into the chat. And I open the voting and ask members to vote. If every member has had the opportunity of casting their votes, then I ask the Greffier to close the voting. The principles have been adopted, 33 votes for, no votes contrary, no abstention in the link, and a further 5 votes for in the chat. Deputy Hegrar, I assume your panel doesn't wish to scrutinise this matter?
No, thank you, sir.
Very well. How do you propose the regulations, Minister, in second reading? There are obviously just the two of them.
En bloc, sir, please.
Very well. Is there any, are the regulations seconded in second reading?
Yes, sir.
Does any member wish to speak in second reading? No member wishes to speak in second reading? Then there is no debate, and I ask the Greffier to place a voting link into the chat. I ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The regulations have been adopted in second reading, 33 votes for, no votes contrary, no abstention in the link, and a further 9 votes for in the chat. Do you propose the matter in third reading, Minister?
Before I do so, I'd like to thank everyone everyone that has voted for this smaller change, but it will really affect the lives of the people who do this caring, and they've been waiting quite a while. So I thank them and I propose it in the third reading. Thank you, sir.
Is it seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? No member wishes to speak in third reading. Then there is no debate. In the light of the voting history, I'll take this as a standing vote, unless any member indicates in the chat that they wish the appel. Very well, there's a request for the appel. I ask the greffier to place a link into the chat. And I ask the greffier to open the voting and members to vote. Many members have had the opportunity of casting their votes, and I ask greffier to close the voting. The regulations have been adopted in third reading, 33 votes for, no votes contrary, no abstentions in the link, and a further 8 votes for in the chat. Very well. The next item of public business is the changes to the objects and purpose of the Anne Alice Rayner Fund, P92, reissue lodged by the Minister for Treasury and Resources. For these purposes, the main respondent will be the Chair of the Corporate Services Scrutiny Panel, and I ask the greffier to read the proposition.
The States are asked to decide that they are of opinion to amend the Act of the States dated 27th of March 2001 concerning the Anne Alice Rayner Fund. 1. By deleting the words "or philanthropic" where they occur in paragraph A2. 2. By substituting the words "the Minister for Treasury and Resources" for the words "the States" where they occur in paragraph A2. 3. By substituting the following paragraphs of paragraphs B1 to B4. 1. The income of the fund shall be administered by 4 individuals or by the board of no fewer than 4 individuals of a single independent corporate administrator appointed by or removed by the minister on the recommendation of the trustee on such terms and conditions as the minister considers appropriate. 2. The income administrators may, at their absolute discretion from time to time, make grants or loans to be secured on immovable property on such terms and subject to such conditions as they determines out of the returns of the fund for the relief of needy persons residing in Jersey. 3. The Minister for Treasury and Resources may from time to time propose to the states other objects and purposes of a charitable nature to be approved by the states for inclusion in the objects and purposes of the fund, and renumbering the remaining paragraphs accordingly. And 4. By substituting the words the Minister for Treasury and Resources for the words the Finance and Economics Committee throughout paragraphs B and its subsequent paragraphs.
Yes, Minister.
Thank you, sir. Sir, the Anne Alice Rayner and Greville Bathe funds are two substantial bequests that the bailiff, Jurats, trustee and assembly have previously agreed should be administered together. Their current values at the end of September were £3.8 million and £23.1 million respectively, and the funds have typically distributed approximately £185,000 and £785,000 per annum in recent years. The Treasurer of the States is the official trustee of both funds. However, the activities of income administration are performed separately by independent appointees. Until recently, these appointees were 4 individual jurats of the Royal Court, in accordance with the wishes of the late Greville Bathe and the requirements of this Assembly for Anne Alice Rayner. So I would firstly like to place on record my personal thanks to the jurats, both past and present, for performing this role with compassion and wisdom over many years. It has become clear over the last couple of years that the burden this role is placing on our extremely busy jurats is increasing, and the context within which the funds are operating has changed. With this in mind, the jurats have expressed a desire to collectively stand down from the important role. This decision has already been formally notified to the trustee by the bailiff. As a result, it is necessary to appoint new income administrators with immediate effect. Consequently, it is necessary to ask this Assembly to agree to amend the stipulation of P38/2001, which stated that income from the AA Rayner Fund is administered by jurats. Having received the current circumstances of both funds, the trustee is recommending that I seek members' approval for a variance to the trustees to provide the option to appoint a single corporate body as income administrator. Such body to have equivalent quorum requirements, i.e. a minimum of 4 individuals, in order to preserve the wishes of the settler. This will mirror changes recently approved by the Royal Court for the Greville Bathe Fund. So the scrutiny panel have raised various points about these proposals, which I will address in the course of my speech. I thank them for their comments. These comments were received on Friday and helpfully identify areas for clarification in my speech today. To this end, before I proceed further, I must reiterate that 1. These proposals fundamentally relate to AA Rayner, not wider gift funds. 2. Are made with an intention of enabling income awards to contribute to be administered alongside those of Greville Bathe. And 3. Are in essence about appointing a new income administrator to continue the same work and type of awards as the outgoing administrator. So as the scrutiny panel identify, the changes have been developed in a compressed timeframe. The jurats' intention to stand down in October was communicated in February 2021, and the initial proposals were formulated soon after. Between then and now, the majority of the time taken has been tailoring the proposals in reflection of discussions with the Jersey Charity Commissioner, the Charitable Funds Oversight Board, and the Law Officers Department. The changes were publicly advertised for a month in July in various media, plus letters inviting comment were written to recent sponsors, including citizens' advice groups and groups that have applied for awards and to recipients. The proposals were then delayed by the summer recess, and extra time was spent refining the Greville Bathe representation to the Royal Court to accommodate certain wishes of the Charitable Funds Oversight Board. Latterly, the the scrutiny panel have engaged a review which took further time. I'm sure you will be aware these processes, whilst necessary, have resulted in the delay of the Q3 awards, and there are currently over £300,000 of application pending from needy applicants. I recommend that sufficient review by many parties has taken place, and the priority now should be to make a decision rather than to delay further. There are three main arguments in favour of the change to allow the appointment of an independent corporate income administrator, whose appointment or termination would be transferred from the Assembly to the Treasury Minister. Firstly, the changes will facilitate access to the necessary skills, resources and infrastructure that is increasingly needed to support the funds in a modern fiduciary context. Professional administrators are better placed to meet the increasing governance standards around award making and outcome evaluation. Secondly, the changes will enhance structural aspects of governance, transparency and the independence of the income administrator role. Individual appointees rely on Treasury officials to gather, store and process information critical to decision making. This creates a dependence on government officers and potential ambiguity around the separation of roles, most notably in the event of dispute. The new arrangements will formalise the respective accountabilities and standards. Thirdly, it is anticipated that a centralised income administrator role would provide the funds with better public visibility, better coordination of outcomes, and simplified partnering with external bodies. Additionally, over time, economies of scale would be better achieved as smaller gift funds are able to access the expertise available from a centre of excellence. These arguments have been considered by the Royal Court and deemed appropriate grounds for equivalent changes to the deed of the Greville Bathe Fund. So this proposition introduces a power for the Minister of Treasury and Resources to appoint or terminate appointment of the income administrator on a recommendation of the trustee. In the absence of the role of the Royal Court to make appointments of jurats, a new mechanism of appointment needs to be formalised that enables the appointments to remain non-political. Since the trustee retains overall fiduciary responsibility for the funds, as per the settlers' wishes, it is appropriate that the Minister should make the appointment or termination on the recommendation of the trustee. The scrutiny panel have queried whether transferring trusteeships under an oath of the public trustee model would set precedents for other gift funds or be incompatible with aspects of the public finance law. I'm happy to clarify to the Assembly that this proposition does not concern trustee structures. The Assembly, via the Treasury Minister, retains control of the appointment and termination of the income administrator. The trustee, the treasurer, retains both the control of the fund assets and a personal fiduciary responsibility for the governance of the fund under the Trusts Jersey Law 1984. Sir, the scrutiny panel refers to an Office of the Public Trustee consultation. To be clear, this is a separate exercise with slightly different goals, which I will explain later. The proposition also includes the deletion of the words "or philanthropic" with the objects of the trust. The purpose of this change is to make it clearer that both funds continue to meet the public benefit test, i.e. remain charitable rather than private. In practice, this will not affect the nature of awards being made. The scrutiny panel have queried removing reference to the word philanthropic from the wording of the fund and have suggested that terms should be introduced that provide specifically for nurses and patients in hospital in need as well as hospital equipment. So I do not propose to narrow the definitions in this way, which would be a regressive action. In Proposition P38 2001, the Assembly acknowledged that by 1952 obligations towards hospital and equipment spend had effectively finished, and that since then the purpose of the fund have been to make awards to the needy. That is the current working mandate of the fund. Restrictions on awards to groups of individuals were purposely removed in that proposition to give a wider discretion, so that the, quote, so that the income can be distributed where it will do most good, unquote. The criteria of pecuniary relief to needy persons of Jersey will continue to apply, and this shall neither exclude nurses nor patients. To recap, these changes are for the permanent benefit of the fund. They will enable a corporate body, such as the registered charity or a regulated trust company, to fill the role of income administrator, should the trustee consider it desirable. I'm happy to provide the Assembly with detail about the first income administrator the trustee is recommending for appointment, though it should be noted that this appointment is for a fixed pilot period of only 18 months, and this proposition concerns the permanent option to appoint or remove such types of income administrators. If approved today, I initially intend to accept the trustee's recommendation to appoint the Jersey Community Foundation, the JCF, as income administrator for the Anne Alice Rayner bequest. The JCF is a registered charity and as such is under the oversight of the Jersey Charity Commissioner. It operates on a non-for-profit basis. It is the incumbent administrator of the Jersey Lottery and Reclaim funds, and for reasons of expediency, these administration models and their service level agreements provide the structure of the proposed relationship. Although other potential partners exist, it has been expedient to work with the JCF in developing the proposals in the limited time available. As I have mentioned already, the initial appointment would be for an 18-month fixed-term pilot so that the trustee has sufficient time to review the success of the single corporate administrator model and to determine whether this model should be pursued as a permanent solution. The Charity Commissioner would also use this period to evaluate the appointment, firstly, to determine whether in practice the awards made are charitable in nature and thereby a registered charity is a suitable administrator, and secondly, whether such a corporate administrator is competent to make the awards effectively on a permanent basis. Furthermore, within that 18-month period, the trustee has undertaken to provide the Charitable Funds Oversight Group Board with a report on the sustainability or otherwise of the creation of an Office of the Public Trustee. This is a reform initiative covering various aspects of governance and structure across the span of Government of Jersey administered gift funds. Income administration is one strand of this reform, hence the link to the initial pilot appointment. So I would like to reassure members that this is solely an administrative charge. Significant and detailed discussions have already taken place with, amongst others, the Charitable Funds Oversight Board, the Jurats themselves, the Jersey Charities Commissioner, and the Citizens Advice Bureau. So I hope that members can appreciate the proposals I'm bringing today are necessary and urgent. They are intended to ensure that the administration of the income from these very generous bequests that were made over 40 years ago continues in a manner that is aligned to the settlers' original intentions, whilst also meeting modern fiduciary standards. I can genuinely say to members that I believe these changes will allow even greater access for islanders who might be able to benefit from the legacy left to us by the late Anne Alice Rayner. Sir, I make the proposition.
Very much. Is the proposition seconded?
It is, sir, yes.
Very well. Senator Moore.
Thank you, sir. So the panel's comments note that the proposal does provide the foundations for enhanced government accountability, transparency and standards for the administration of the fund, although it is lacking in the detail that should be expected by this Assembly, and we consider that the Minister should withdraw and improve this proposition. The panel has various concerns in relation to the detail contained in the proposition, which it concludes should be addressed by the Minister. Sadly, we find that her work has been insufficient and requires improvement. Unfortunately, there was not enough time for us to bring the required amendments ourselves. The Assembly should note that the timetable to the lodging of the proposition is disappointing. It is evident that you, sir, provided considerable notice of the intention, 12 months, of the Jurats to stand down to the Minister for Treasury and Resources. However, the Minister did not lodge the proposition until the 28th of September of this year and did not update the panel of her intended actions. The urgency is merely a consequence of lodging the proposition at such a late stage, so that the Jurats who are standing down have restricted opportunities. And it also has limited the options available to the Minister herself. It has been argued that this would prevent people and groups from benefiting from the allocation of these funds. However, it is highly possible that the Jurats might continue, if they were asked politely, for a short period longer, as it has been noted by the Minister that they have done to date an excellent job, although an increasingly onerous one, and we all appreciate that they are a very busy group of people. We have no issue, sir, with the selection of the foundation to provide the selection and allocation of funds. And the panel would also like to thank the Comptroller and Auditor General and the Charities Commissioner for their written submissions to assist the panel's work. The panel, however, are concerned by a number of items, and I will elaborate here. So we're concerned by the removal of the wording or philanthropic from the terms of the fund. The Minister indicated in evidence provided to the panel that this was due to the purpose being absorbed by the States of Jersey. And as the Minister has just described, the panel would question whether the whole purpose in relation to a nurses' home and hospital equipment has actually been provided by the states or government of Jersey. The panel would request confirmation from the Minister as to the location of the nurses' home that was provided by the Alice Rayner Fund and whether it is still providing accommodation for nurses. The Minister's suggested today that it is no longer necessary for nurses to receive philanthropic support from such a fund. However, and sadly, the panel has received a representation from a nursing body that states quite the contrary. Members, I'm sure, will be aware of the hardship that some nurses are experiencing in current times, and this should, of course, not be the case. But why, at this time, remove the access that nurses and their colleagues might be able to benefit from when it is clearly needed in our community? The panel would suggest that amendments should be considered to provide specifically for nurses and patients in hospital in need, as well as specialist hospital equipment that is not provided by the States of Jersey, to deliver against the specific purposes of the bequeathed funds and to conform to the requirements of the charities test. Members of the Assembly may well be able to think of examples where this fund would be particularly beneficial. For example, specialist equipment for cancer patients, which isn't provided by the government of Jersey, but which has a significant benefit to a patient in need, or could help nurses with rental costs or a subsidised travel card. This would then ensure that the fund is targeted and specific to the fund's core objectives and to allow Anne Alice Rayner's gift to the island to achieve its objective. To date, it appears that opportunities for individuals or groups to benefit from these funds have often been lost because they did not know about it. And in future, we hope that there will be better signposting through the use of the Jersey Community Foundation. And we were certainly grateful for the time that we spent meeting representatives of the foundation and feel assured by their experience. The panel are, however, concerned that the proposition goes beyond amendments of the Anne Alice Rayner Fund, and that it would appear that the Assembly, in agreeing this proposition, would set a precedent for the management of other gift funds held by government. But that does not form part of the proposition put forward to the Assembly today for approval. The Assembly should also have been asked to agree that action should be taken to provide for a study of a public trustee. The panel are concerned that the transfer of the trusteeship to an independent body will affect the responsibilities of the Treasurer as trustee and accountable officer as defined in the Public Finance Law. Also, evidence provided by the Charities Commissioner confirms that the public trustee would need to be wholly independent or both the Ministry and Legislature, otherwise it would not meet the charities test. Therefore, to enable this fundamental action to be completed, it should have been formed as part of the proposition for the Assembly to approve, and the reasons should be clearly detailed. The accounts for the Anne Alice Rayner Fund have not been published on gov.je since 2017. The Assembly should be able to access up-to-date records of the fund to inform its decision-making, which the panel has been advised is around £350,000 per annum. The Charities Commissioner pointed out to the panel that significant work and governance is needed to spend £250,000 wisely and well. The Commissioner also pointed out that the median annual expenditure of registered charities was of the order of £37,000. So this fund is significant in size locally, and it must be correctly structured. Accountability. Given the different responsibilities of each stakeholder, it is vital that the lines of accountability are clear within the proposition. The panel have highlighted in its comments that various issues with terminology and reference points which require clarification, and the panel would encourage the Assembly to consider our Commons paper carefully in regard to this area of concern. The proposition report confirms that the 18-month pilot period is an interim solution in relation to the income administrator appointment. The panel concludes that the Minister should agree to a formal consultation on the outcomes of the 18-month pilot programme as recommended to the panel by the Controller and Auditor General. The lodged proposition and report for the Assembly the Assembly's consideration is silent on various engagement terms of the independent corporate administrator, including confirmation on costs. The panel concludes that the terms of the service level agreement should be provided to the Assembly to clearly inform its decision making. So, as stated in our comments, we do not find that there's been adequate consideration of this proposition, and the Minister should, in an ideal world, withdraw and return with an improved proposition. As it appears clear that the Minister will not observe our request, we suggest that members vote against the proposition.
Thank you very much. Senators, any other member wish to speak on the proposition? No other member wishes to speak? Deputy Morell.
Thank you, sir. And I'd like to first of all start by thanking the Jurats for their years of service on this, and I can understand why they feel they're unable to continue their work. Obviously, the scrutiny panel has raised various concerns, not least the fact that this was notified back in February and is only just coming to us now. But I would particularly like to focus on the move of the income administration role to the Jersey Community Foundation, and I question whether that is an appropriate move. And to be honest, the Assembly hasn't been given enough information to really know. Now, for most of us, I believe, our understanding of the Jersey Community Foundation is that, for instance, the dormant bank accounts, the lotteries proceeds are passed to them and they receive applications, they assess those applications from other organisations and then allocate the money accordingly. Indeed, this is talked about in the only statement that I've been able to find about the aims of the Community Foundation, and that's actually on the Charity Commissioner's website, because to be honest, sir, there's very little on the Jersey Community Foundation website which tells you about what the Jersey Community Foundation does. And my concern is that the Jersey Community Foundation may not be an appropriate place for this, because we are talking about here individuals who are in times of need, having to go to a body that they don't know. That happens. They don't know Durats either. But I wonder whether people may feel more reassured that Durats, whose very work is obviously highly discreet and involves confidentiality at all levels, I wonder whether people will feel the same sense of discretion and confidentiality with the Community Foundation, because at the end of the day, we are asking people to open themselves up and say, I need some help. And we're sending them to a body that isn't easily recognizable to people, because it's been principally an organization to organization body. And now we're talking about it being a body which moves to individuals. And so when I read through the registered public benefit statement that the charity has on the Charity Commissioner's website, it does say that it will that the JCF's charitable objects are to pool, steward and deploy by way of grants or other payments from charitable structures, individuals, families, businesses, funds, Government of Jersey or any other body to support the community of the island of Jersey, provided always that such support is by way of grants or other payments to Jersey registered charities and or accepted foreign charities as defined under the Charities Jersey Law 2014 and or to charitable purposes. Now, no individual is going to be a registered charity, sir. And I would not call an individual a charitable purpose. Indeed, to call an individual a charitable purpose, I think, is undermining the humanity of that individual. And so, sir, maybe I should have asked this as a question to the Solicitor General. Are we sure that the terms and the objects of the Jersey Community Foundation are in line with the job that we are asking it to do here? I would also, as I said, ask whether we can be sure that the Jersey Community Foundation will treat in the absolute utmost discretion the individuals who have to go to the foundation to ask, literally to ask for money to help themselves. And I really do wonder if that's the right thing to do so. And so, sir, I don't suppose I'm allowed to seek your advice, but maybe this should be better asked as a question to the Solicitor General. Is the Jersey Community Foundation allowed by its own objects to provide money to individuals who are not registered charities? Thank you.
Mr. Solicitor General, are you able to assist on that question? The question is the Jersey Communities Foundation permitted by its own regulations, articles, or whatever they may be, to advance monies to individuals as opposed to charitable bodies?
Well, I can answer that, I hope, in this way. First of all, the Royal Court, in its consideration of the Greville Bay matter, was content that it could and that it was appropriate. Second, the Charity Commissioner, who has considered it, is content that at the moment what is recommended is appropriate. Third, primarily, it seems to me a matter properly for the Treasurer and the Jersey Community Foundation, pursuant to a service level agreement, to ensure that it works in an appropriate fashion, given that, as I understand the proposal at the moment at least, it's intended to be an interim one. That's, I think, the best answer I can give.
Thank you very much, Mr. Solicitor. Deputy Young.
Thank you, sir. I share the unease of this, having read through the proposition and the comments. Quite a number of questions occurred to me going through. And of course, I was reminded when years ago in a former life, I was the Treasury in the 1970s, and I remember these funds They were then, I don't think, anywhere near as substantial sums of money as they are now. Looking at the last published accounts in the reports on the gov.je website, the accumulated capital on this Rayner fund is about 4 million, or was, and the Greville Bay 20 million. So we're talking about very substantial sums of money. And the context, I think these were monies gifted by private families, bequests, and because it goes back to the days when, if you like, there was, kind of very high level of trust in sort of government processes, I think, to do that. And obviously what they did is the then Treasurer of the States took them on as part of the various pockets of money that they've got. I think these two are probably some of the largest. And I suppose tried to, was both a function of a bookkeeper and an administrator, I think, in those days. And they used to publish annual accounts, and I think they still do, in the accounts of the Treasurer of the States. So, as it were, because government has taken on this role, there is, I think, quite a substantial moral, if not legal, I'm sure there's a legal obligation to ensure proper management of these funds. And of course, I'd be very, very surprised if anybody set them up such a thing today. But of course, I do remember the way they were working. They were, my memory tells me, in those days, there was no income support of Social Security. There was none of that. There was none of the benefit structures that we have today. And we had parish welfare. And people fell through the net on parish welfare. And this is why those funds were, I think, in place to substitute or to pick up some of the gaps that were in the parish welfare system of the day. And of course, now here we are, 40 odd years, probably even 50 odd years, probably after these. And I can't see any new such funds being set up. My expectation would be, having worked as a law firm, is that people making such bequests, I think they'd be very unlikely to go to government and say, would you look after these monies? They're more likely to go to a law firm and ask to set up some device and to settle the money in that. And there will be a thing called a trust deed that sets the rules. And then there's clear accountability. But here we got it within government. So some of it in here, because the Treasurer then is taking on a major role. I think while we had the Durats working, obviously we had, I think, that separation of the, the system. But now I can understand why absolutely the Durats want to exit from that. But is it necessarily right to give such a role to a treasurer? I mean, it's bound to, if it, on what part of the role says, well, the Treasury Minister is able to suggest new objectives. I'm pleased it does say at least those purposes of the fund should be come to the states, I think. But nonetheless, it's kind of all locked in. And I wonder, is it still going to continue that these funds are part of the accounts of the Treasurer of the states? And I do wonder about, what independent advice we've had. I just heard about from the Solicitor General about, well, it's the Treasurer and so on. Well, is that all right then? I'd like to feel assured that this is as robust as it can be, because people who gave money years gone by should make sure that those arrangements in place. I also wonder, are there any surviving members of the family that would have a view and opinion how these funds should be managed and dealt with? So I'm sorry, so these are unanswered questions for me, particularly if this is to be a model of the way forward for lots of these other funds. So I apologise to the Minister, but that's I think it is our job here as kind of, the final decision making, whether we feel that we can be confident about this change or not. But it is about arrangements for managing of private money. not government money. And I think we have to be especially careful.
Thank you very much. Deputy, there are 2 questions to be posed for the Solicitor General. Deputy Higgins, you have a question?
Yes, thank you, sir. And I apologise to the Solicitor General if he did mention this, but I was trying to listen closely and I didn't hear the answer. Deputy Morell asked whether it covered individuals. And although he talked about the court and he talked about the Charities Commissioner, I didn't hear him actually say, yes, it does cover individuals. So can he please clarify that? Because again, like many other members, I am very concerned about this and likely to vote against. Thank you, sir.
And Deputy Morell, you have a second question for the Solicitor General. I thought I'd give him all the questions at one go so that he could work out if there's a way of answering them succinctly.
Thank you, sir. Yes, in his response to me, the Solicitor General, the question I asked was whether the objects of the Jersey Community Foundation, which require it to award grants to registered charities, would enable it to undertake the work being proposed by the Treasurer here. He said yes, and this had been confirmed by the Royal Court. I wondered if he could tell me how the Royal Court confirmed it, in what forum, in terms of why was the Royal Court being asked, sir? Because I couldn't find anything in the report which suggests that the Royal Court have determined whether or not the Jersey Community Foundation and has the correct aims written in its objects to allow it to make donations to individuals. So I'd be grateful if the Solicitor General could explain more clearly how and why the Royal Court determined this. Thank you.
Thank you, Deputy. There's also a question from Senator Valwa.
Yes, thank you, sir. Could I ask the Solicitor General to explain the independence of the Treasurer under the Public Finances Law in accumulation with regards to their responsibility as a Director General as assigned by the Principal Accountable Officer under the Public Finances Law, and how those 2 interactions affect the ability to objectively assess the fund administration of all the funds that sit under the states, but in particular in relation to the Alice Rayner Fund and the Greville Bay Fund. Thank you.
Do you wish some further time to consider your answers to those questions?
That last question is a very involved one, and I can't undertake to answer it shortly. Probably not shortly this evening either. The other questions I'm happy to deal with now. I have not seen the foundation documents of the Jersey Community Fund. What I can say is this, reminding myself of what the testatrix, that is Anne Rayner, said in her will, which is that she was bequeathing the money for charitable purposes, which were grants of pecuniary relief in any form to needy persons of either sex of the professional classes residing in Jersey. She talked about the relief of the poor. There is, first of all, no reason why that needs to be construed in terms of any charity or the fund giving directly to individuals. It does not preclude the Jersey Community Fund meeting those wishes of the testatrix by making grants to other charities which are able to have those sorts of things as their objects. That's the first point. In terms of accountability, as I have understood it, of course, the Jersey Community Fund is accountable to the Treasurer, in this case, the trustee, in this case, the Treasurer. And its actions will be subject to a service level agreement. So if there's any suggestion that the JCF is not meeting the wishes of Anne Rayner, that would be a matter for the trustee in the exercise of his fiduciary duty to take the JCF to task over. Ultimately, it may be by making a recommendation to the minister to remove JCF as the income administrator of the fund. So that's, I hope, an explanation for how it would work. In terms of the Greville Bay Fund, that was a separate matter a separate fund, and it went to the Royal Court because Mr. Greville-Bathe in his will gave a much more limited role to the States Assembly in terms of the fund, and it was limited simply to appointing jurats. Alice Rayner placed a very much greater responsibility on the states, giving to them the power directly to administer the fund in such manner as they might resolve. So the Greville-Bathe Fund is something of a side issue in terms of what the states are being asked to resolve today. So those are the answers I could give to Deputies Higgins and Morell. I don't immediately have an answer to Deputy Valois. Her question was a long one. I wonder if she'd mind, if she can, perhaps sending it to me in writing, and I will look into it as much as I can this evening.
Thank you very much, Mr. Solicitor. Well, then we continue. Senator Ferguson.
Thank you, sir. I do wonder about the ability of the Treasury to plan the proper administration for these funds. Until we had our first Auditor General, Chris Swinson, he recommended the change of administration of the funds, putting them into an umbrella fund so that there could be better returns. Up until then, all these little funds, big and little funds, were all invested separately. It was an absolute nightmare. However, if it required the advice from the CNAG to make a sensible change, can we rely on the Treasury to make these latest changes? I mean, how soon do these funds become a magic money tree for HNSS and the Jersey Care model? You know, we've only to look at the record of the LaSalle Fund, which was in fact administered originally by HSS, and the Oxford Road property. You know, do we really want to possibly expose these funds to that sort of approach? I'm extremely unhappy about the whole process. I thoroughly agree with the Corporate Services Panel's comments that, you know, there are too many questions to be answered. Thank you, sir.
Thank you very much, Senator. Deputy St Mary.
Thank you, sir. I have 2 points regarding this. The first is it so happened over the weekend I was approached by a member of the nursing profession who raised this very point and had only recently become aware of the Alice Rayner Fund and made the point himself that had other nurses been aware, they would have been motivated to make applications towards it. So I would be interested to see accounts, see how much use of the fund has been made in that direction. And the other point, sir, relates to the appointment of the income administrator. References have been made to the Jersey Community Foundation, and I know them from the work this panel did in relation to the application of Channel Island lottery proceeds. But at that stage, sir, and before scrutiny effectively endorsed or supported the proposal to distribute lottery proceeds, we had a service level agreement in our possession, which laid out the framework of their way of thinking and how it might be applied. And without a similar document here, so I'm in difficulty in being convinced that the foundation or any trustee would know the root intentions of the settlor or the testatrix so as to better apply the income. So I am minded at the moment, sir, to vote against the proposal for that reason. Thank you, sir.
Thank you very much. Does any other member wish to speak on the proposition? Deputy Martin.
Yes, so I'll be brief, and I've listened to the debate and the legal advice. And when the minister sums up, I think we're in a sort of a where we are place, because quite clearly the jurats, with all their other busy work on their main job, let's say, I call it their main job in the courts, they don't want to administer this fund. And if we can't give it to revenue at the moment and then sort it out. This could just be a fund that's just not used for quite a while. So I'd just like the Minister, when she sums up, to sort of say if there's a plan B. I did hear Senator Moore say, ask the Jurats nicely and they might do a few more months. Well, I think they're not walking away, they're running. They do not want to do this. It's clear they do not want to do this. They haven't got time to do this. So do we want this fund that just sitting there, not administered by anybody and actually not helping anybody that it was set up for? Thank you, sir.
Very much. Does any other member wish to speak on the proposition? Senator Barwell.
Yes, thank you, sir. I'd just like to raise the issue. Deputy Martin just referred to funds that are not used for what they're necessarily used for in various areas. I did raise the question with the Solicitor General. I understand that he needs more time to consider that. But there is an issue here. So funds are set up for a specific purpose by people who are willing to put their money to things that they think are appropriate for the public of Jersey. Alice Rayner Fund is an example, but what's unfortunate in this proposition, it also makes a kind of sudden change to the Grenville Bay Fund that isn't quite clear and transparent in the overall proposition itself. So we need to talk about openness and transparency in regards to the actual overall proposition itself in terms of what we're talking about. We have to recognise that people have entrusted the funds that have been bequeathed to the public in the absolute important and monetary factor that they expected that these funds would be expended to. And so when we talk about the issue of Alice Rayner Fund and how it could have been administered, corporate services have heard from members of the public or unions with regards to the health service, where funds could have been used for specific equipment requirements that, you know, the government weren't willing to provide the money for, but which were more than likely amenable under the requirements of this fund. And there is a question in which, and yes, I do sit on the Corporate Services Scrutiny Panel, but I'm talking from as a member of the Assembly. When we look at the requirements and the specific objects of the use of the fund in terms of promoting the happiness and comfort of the inmates of the poor, Law Department of the General Hospital, provision of up-to-date equipment for the treatment of patients as the said hospital, pecuniary relief in any form to needy persons of either sex or the professional classes residing in Jersey. There has been an issue over many years, whether I've sat on various scrutiny panels, whether I've been in the various ministries that I've served in, I've raised an issue of how we overlook and support and ensure that these funds are being used for the appropriate objectives that were placed for the public that were in need. And we've seen a number of times over previous years where Treasury have put in requests to the Royal Court to change the requirements of funds because the historic nature of the language has not necessarily enabled the provision of funds to what was expected. And so for me, I don't think this proposition actually covers the overall request, and I do wonder whether it actually goes further, because it's not just on the Alice Rayner Fund, it's actually on the Grenville Bay Fund as well. And there are many, many, many other funds that sit under the government. And my concern sits with how the Public Finances Law currently sits for our pecuniary interests. So I'd expect a treasurer to be completely independent. and holding the principal accountable officer to account for the way that funds are being expended. And I'd also expect that the principal accountable officer is able to show how they're spending those funds. But should an efficiencies plan or should something else come up that says we're going to spend more money in this area and we're going to reduce money in this other area, but guess what? We've got this fund on hand where we can take some money and make a proposition to community foundations. This is where it gets slightly concerning for me. And bearing in mind, the principal accountable officer can appoint the treasurer as a director general, as is currently the case, and therefore calls into question the independence and therewithal of how the trustee administration works with regards to the responsibility that we have to the people who have bequeathed their funds and requests to the public for this funding. This isn't just general taxation funds. This is people who have decided that they want money that they had to go into certain requirements. And so that's why I raise these issues now, sir. And I think it's important that I do so, because it's a much larger consideration with regards to how we handle public finances and how they're attributed to outcomes for tangible public effect. Thank you, sir.
Thank you very much, Senator. Mr. Solicitor General, do you wish to speak to the Assembly now?
So, yes, I don't think it's necessarily a straightforward question that Senator Valois raises, but I think the answer is this. This is not, in my view, a public finances law situation. It's about charitable funds that have been bequeathed for a charitable purpose. The whole idea is that the fund administrators are meant to be independent of politics. The structure that has been created with accountable officers and the Public Accounts Committee and so forth is very much part of a political structure, which is at odds with the purposes of the Anne Rayner Fund, hence the idea of having independent fund administrators. That is not to say there is not some oversight over the way it's managed. For this reason, the JCF is answerable to the Treasurer as trustee. The Treasurer as trustee is bound by a fiduciary duty, which is subject to the island's trusts law and its customary law on trusts. And therefore there is a supervisory role in law through the courts. There's also a supervisory role that does ultimately rest with the Assembly, because the Treasurer is answerable to the Minister for the manner in which the fund is used, in the sense that if the JCF is not operating as it should do, then it's incumbent upon the trustee to procure the removal of them, which would be done by reporting and advising the Minister that that should happen. Of course, the Minister is in turn accountable to the State's Assembly. Now, that may be more convoluted than the standard accountable officer public accounts route, but I don't think, I'm not convinced that this falls within the standard public accounts structure, which is first and foremost an underlyingly a political system. I hope that's to some extent helpful.
Thank you very much, Mr. Sister. Does any other member wish to speak on the proposition? No other member wishes to speak. Senator Moore.
Sir,
I'm afraid you've already spoken.
I appreciate that, but I think I can still, under Standing Order 83, propose a reference back.
Thank you very much. Yes, sir.
If I may, sir, I think during this debate it's become clear that additional information is required from the Minister.
Well, so could I then ask, your correct standing orders say that any member of the Assembly may propose without notice during a debate on a proposition that it be referred back either for further information or to clarify any ambiguity or inconsistency. So in making your application for a reference back, would you indicate what information it is that you think is necessary?
Indeed, sir, and I think that it's become clear during this debate, and I'm grateful to all those who have spoken, and particularly to the Solicitor General for his advice, that there is a level of ambiguity over the removal of the word philanthropic and the impact that that might have upon people who would have, under the original intentions of the fund, benefited from it. We're also reminded of the comments of the Charities Commissioner in relation to the inability of the Community Foundation to give apportion funds to supporting individuals, which would also be against the original requirements of the fund, and therefore we would like, and I sense that the Assembly members also see the points that the Corporate Services Scrutiny Panel has been trying to raise in its comments and in my earlier speech.
So you are seeking clarification on what you say to be an ambiguity on as to the impact of the removal of the word philanthropic, and you are asking that the Jersey, the charitable fund, given that it cannot give to individuals, how it can properly be effectively the administrator of this fund. Are those the two pieces of information that you're seeking?
I think that's what the heart of the problem is. So yes.
Very well. Is the proposition for reference back seconded?
Yes, sir.
Yes, sir.
Very well. Does any member wish to speak on the matter of yes, indeed. Hold on a moment. Deputy Ward, did you wish to speak on the reference back?
Thank you, sir. Well, I was going to speak on the main proposition, and I was actually going to say that I would ask for a reference back, but there was so much in terms of what's going on here that I'm unsure about. I was unclear as to how much of a reference back, so to speak, I would ask for. And so there were so many pieces in this, and I too have been contacted by representatives of nurses saying what is happening with the Alice Rayner Fund. It wasn't a fund that was well known, and therefore these changes are making it even more difficult for a specific fund to be accessed. And I think that's one of the issues that we've got here and why we need a reference back. We don't know, to put it simply, what this fund will look like afterwards compared to what it looks like now, because actually what it looks like now is not clear to many people anyway. And I don't think that the solution that has been, well, a possible solution to something where we don't really know what the problem is, apart from the Durats not wanting to control this anymore, which is, I think, a slightly separate issue, and another way around that can be found. But the nature of this fund seems to be being put into one great big merger of funds, which will lose the very nature of it as an individual charitable fund set up for very specific, it seems to me, reasons. And so there is so much more information required on this. And indeed, for the reference back, I would add what the nature of this fund now becomes compared to what it was in terms of its link to nursing and healthcare and equipment, for example, because I can't see what it's going to look like now. Whereas, and I cannot say I was particularly aware of it beforehand. It's not something that's come across to my attention, really. I'm not a healthcare professional. Why would it? But when healthcare professionals have contacted me and said, we are really concerned about these changes to the Alice Rayner Fund. And then, to be quite frank, so we see a comments paper that clearly says, which has been considered and clearly says, look, you know, why don't you withdraw this and come back to us after more work has been done? And it does seem that that has been completely ignored, and it's just been brought to the Assembly anyway. And I think so that we can't continually allow that to happen. So I think the only way out of this is to have a reference back on the specific issues that have been raised, and then come back to the Assembly with something that has more clarity, is more understandable, and gives a much clearer definition of picture of what this fund will look like after the changes, so that we can compare to it before the changes and see whether that's the right thing to do. Because we can't, I cannot see how we're deciding that this is the right thing to do on the information we've got at the moment. I simply cannot decide, and therefore I will vote against it. And that too may be the wrong thing if the right information is brought to us. It's bad proposition, it's bad legislation, it's a bad move, and we've got to stop this happening. It's happening too often. So I would urge people to support the reference back. Thank you, sir.
Very much. Deputy Gardner.
Thank you, sir. And interestingly enough, I put my request to speak before Senator Moore proposed the reference back exactly for the same reason. And as Deputy Watt, I tried to finalize why I'm asking for reference back. I will add 2 points for the points that have been made. When we are looking through the report, it's written at the last page of the report that this will be a step forward, from what I understand, towards the aim of securing improved and simplified access to the public. What I heard during the debate, that this is charity that can distribute funds only to the charity, and from that charity it might be distributed to the individuals. So I would like to understand how the proposed change improve and simplified access to the public compared to what we have today. And the second, it's written that its reasonable cost will be deducted according to a pre-agreed budget. I would like to know the schedule, how much it will cost to run, what will be the implications of the cost to implement this scheme in this form. Thank you.
Thank you very much, Deputy. Senator Gorst.
So I did actually put my request to speak in whilst we were on the main debate. It's been slightly, of course, overtaken. I am aware that the Minister has previously deferred the discussion of this proposal to allow scrutiny to do their work. It's unfortunate that scrutiny, of course, still have questions. So it's entirely for the Minister to decide how she would wish to proceed. It seems clear to me, sir, and I beg your blushes, that the Jurats and all those currently involved are satisfied and have raised no objection to what the Treasurer, via the Treasury Minister, is proposing. Perhaps I am one of the few who has first-hand experience of the JCF. I'm pleased that scrutiny were reassured when they met members of the JCF, and I also remind members that this is a trial period. The JCF would be obliged under the terms of the arrangement to issue funds in line with what the trustee, which will become the public trustee, we hope in due course, would require, which again would go back to the original trustee as amended. And therefore I think that the concerns that members have raised, I don't share them, let's put it like that, sir. If the mover of this proposition is asking for a 3-week period to answer those or have further details on those relatively straightforward questions. I'd have thought actually the Solicitor General might have been able to advise on the removal of the word philanthropic and whether that materially impacted the terms of distributions from the fund. I wouldn't have expected it would, because there were other safeguards required and would be put in place. But of course, if the mover has those questions, and then the question about a distribution to individuals, which I'd have thought could be straightforwardly managed with the arrangement that the Treasurer would have, seems to me that they're not insurmountable and could be dealt with either today in the Minister's summing up, or in a straightforward manner in time for a short delay. But I leave that to the Minister to opine upon, sir. Thank you.
Thank you very much, Senator. Senator Ferguson.
Thank you, sir. Yes, I just would like to comment that it also appears from reading the proposition that there is an intention to change the objectives. Now, Deputy Morell has already mentioned, you know, objectives and so on, and what these funds are for. And it just seems to me that we are setting up a magic money tree. So, yes, I think we need clarification.
Thank you very much indeed. Senator Deputy Higgins.
Thank you, sir. I'd like to follow through on what Senator Valois said. I'm very concerned about the impact on the Greville Bath Fund and the lack of transparency. I have accessed this fund in the past for constituents, and it's provided valuable assistance to individuals in need when state departments have been intransigent and, in fact, unsympathetic to individuals and their situations. These funds are very, very important for helping those people who fall through the cracks. And I would hope that in the reference back, we get full information about what's going to happen to the Greville Bath Fund, and especially the impact on individuals. Thank you, sir.
Very much, Deputy Young.
Thank you, sir. I think the proposal is a good solution. Having a reference back, I agree with the 2 points being highlighted. I think that personally, I feel in a situation that the scrutiny report has raised so many issues that it would be irresponsible to discount it. So I do think we need to have a chance to have those questions answered. I would like to add a further area which follows on from both Senator Valois and Deputy Gardner. Listening carefully what the Solicitor General said about the role of the Treasurer, that the Treasurer does have a fiduciary duty, and therefore is subject to all of the ins and outs of the trust law of Jersey, which is an extremely complicated matter. As far as I know, I don't think our Treasurer is a specialist in trust or private finance, and I ask myself the question, is it right to have an arrangement where we've already got a very heavy professional responsibility on our Treasurer that we absolutely trust for public money under the Public Finances Law? And is it right that we effectively ask him to take on 2 jobs effectively, which we inevitably, I believe, conflicts are likely to arise, particularly when monies are being distributed through the funds, private funds, because they are private funds, to private individuals. So and I would like an external opinion to be added in there. And the suggestion I would make is that we ask the Controller and Auditor General for a view of the appropriateness of that arrangement of combining those 2 roles, and if necessary, to take independent legal advice on that, of how that can be managed, because it is a difficult situation. I want to be constructive and find a solution, because I can absolutely understand how the Jurats come to the point where, with the scale of these monies and the importance of it, that they really can't carry on, sir. So I think it's I should be supporting the reference back, and I hope the minister sees that as a sensible thing to do, because if we are going to have a framework of change here, which could set a pattern for other funds, I think it's important to get it right from the off. Thank you, sir.
Very much. Does any other member wish to speak on the matter of the reference back? If no other member wishes to speak on the reference back, then I close the debate and call upon Senator Moore to respond.
Thank you, sir. And I thank all of those contributors who, with the exception, of course, of Senator Gorst, have expressed their various concerns and desires to receive greater understanding of the intentions behind the proposition. It would be a shame, and I think we all agree, to see members vote against this proposition, sir, which is ultimately the position we would be placed in, and what I was advocating in my earlier speech, which is not really what we all want to do. We understand that there is a need to offer an alternative solution to Durats. However, we would like to have our points in relation to governance and accountability, and particularly the issue around the impact upon individual cases, to be answered. Senator Gorst spoke quite late on in this and suggested that perhaps these points could be addressed overnight, but they have not as yet been addressed. And it is clear that that needs to be addressed properly in by some amendments to the proposition. And to be honest, sir, it would be the great preference if that was a job taken on by the minister herself, given that we all have considerable pressures on our workload at the moment, which is perhaps, and I take full responsibility for the delay, reaching this unseemly point in debate, and it should have perhaps been dealt with at an earlier point. But I think I made this case in my speech that there was not sufficient time to make amendments that we had considered were necessary. So I thank members for their support in this, and I ask for the appel, sir.
And as called for, I ask the greffier to place a voting link into the chat. The vote is on a reference back. And I open the voting and ask members to vote. Your vote, Deputy?
Can you register my vote as poor?
Poor, yes. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The proposition for a reference back has been adopted. 24 votes pour, 11 votes contre and 1 abstention in the link. A further 2 votes contre in the chat and 4 votes pour.
So can we have the contre and also the abstention, please?
Contre and abstention, yes.
In the chat, Deputy Pinnell voted contre, as did Deputy Masson, and in the link, those voting contre were Deputies Wickenden, Conatab of St. Juan, Deputy of St. Peter, and Deputy Martin and Deputy Guida. Oops. apologies, the Conotab of Trinity, Deputy Lewis, Deputy Ash, the Deputy of Grouville, Senator Farnham, Senator Lafondre. And did you want to know who had abstained?
Yes, the abstention was after
Yeah,
as well.
it was the Deputy of St. Juan.
Very well. That ends for the time being this particular matter. We are 5 minutes before the time I would normally suggest that we ask about an adjournment.
May I propose the adjournment?
Is adjournment. Very well. The Assembly stands adjourned until 9:30 tomorrow morning.